This is the brief on crimes against persons in Philippine law. So this syllabus really breaks down how the penal code categorizes violence, showing us that criminal liability is dictated not just by the act itself, but by exactly who is harmed and how. You got to think of criminal law not as some blunt instrument, but as a highly sensitive scale carefully weighing relationships, intent, and exact circumstances. First, let's look at the hierarchy of killing. Homicide is your baseline unlawful killing, but it escalates to parricide if the victim is a spouse or direct blood relative, and to murder if you use specific circumstances like, say, treachery or poison. Does this mean the law values certain lives more than others? Well, no. It just means the guilt is heavier when an offender shatters a sacred family trust or uses cowardly, deceitful methods. Second, we have contextual chaos. The law adapts to super-specific scenarios, like a tumultuous affray, basically a confused, multi-person brawl. Think of it like a deadly tangled knot. Since the law literally can't isolate the single fatal blow, it punishes the participants for the violence itself. This also includes infanticide, applying specifically to the killing of a child less than 72 hours old. Finally, let's talk about the evolution of rape laws. It's modernized into two distinct modes: traditional carnal knowledge and non-consented sexual assault involving inserted objects. Crucially, the absolute husband exemption is completely gone. A legally married man can now absolutely be convicted of raping his wife. Why is this shift so critical? It shows the law evolving past archaic ownership ideas to recognize that a violation is fundamentally about the absence of consent, regardless of a marriage certificate. Ultimately, this legal framework proves that justice doesn't just look at the tragic end result of a crime, but meticulously examines the complex web of methods, motives, and relationships that caused it.
A person is dead. There is a dead body, there is a suspect, and there is a weapon. But in the eyes of the law, we don't actually know what crime has been committed yet. In Philippine criminal law, taking a life is not a single monolithic offense. The physical act of killing must be filtered through a strict system of statutory classification before a charge can even be filed. That system is found in Title 8 of the Revised Penal Code, Crimes Against Persons, specifically under Chapter 1, which governs the destruction of life. For law students and practitioners, a dead body presents a specific analytical problem. You have to look at the raw facts and determine exactly what to call the crime: homicide, murder, parricide, or infanticide. To do that accurately, we have to construct a rigid legal decision tree, one built on the variables of relationship, intent, and circumstance. It all starts with one undeniable fact: a person is killed. From here, this tree acts like a mathematical algorithm. You feed the facts of the case into the TAOP, and the flowchart filters those details down into the correct statutory charge. This taxonomy provides the structure for a rapid recall mental model. Whether analyzing a bar exam scenario or building a case for trial, every branch in this tree represents a specific statutory requirement. Let's follow the first path down to our default charge: homicide, defined under Article 249. This is the baseline offense. The legal requirements are straightforward. A person is killed by the accused without any legal justification. But there is a crucial psychological driver required here. The accused must have the specific intent to kill the victim. In practice, proving this is highly streamlined. If the victim actually dies from the attack, the law conclusively presumes that the intent to kill existed. Prosecutors are only forced to actively prove that homicidal intent was present when the crime is incomplete, specifically in cases of attempted or frustrated homicide. And what if there is no body? The concept of corpus delicti, or the body of the crime, is strictly about the fact of death. If a victim is thrown into the sea tied to a heavy weight, their disappearance doesn't negate the crime because death is logically certain. Homicide remains the structural foundation of Title 8. It is the crime that remains once all other qualifying variables have been stripped away. If the killing is accompanied by specific conditions, the charge escalates from homicide to murder under Article 248. These qualifying circumstances include methods where the victim cannot defend themselves, like treachery, acting for a reward, using poison, or evident premeditation. The rule of application here is strict but simple. It takes only a single qualifying circumstance to elevate the crime to murder. If the prosecution establishes multiple qualifying circumstances, say both poison and a hired hitman, the extra circumstances don't create double murder. Instead, one circumstance qualifies the crime, and the surplus variables are treated as generic aggravating circumstances to increase the penalty. There's a critical limitation on stacking variables, known as the absorption doctrine. Under this doctrine, if an attacker employs treachery, that specific circumstance inherently absorbs other related conditions, like abuse of superior strength or the aid of armed men. As established by the Supreme Court in People v. Remolante, the courts will not double count these absorbed circumstances to pile on additional penalties. The lesser conditions are simply subsumed by the greater. Ultimately, murder is a circumstance-driven escalation that demands precise pleading. If the prosecutor fails to formally allege the qualifying circumstance in the information, the charge collapses right back down to baseline homicide.
The legal system places an exceptionally high premium on the victim's identity, creating a parallel track bypassing homicide and murder entirely. The parricide node, under Article 246, requires taking the life of a direct ascendant, direct descendant, or legitimate spouse. The word legitimate recognized as legitimate. Moving to the infanticide node under Article 255, we find a charge with a singular, rigid trigger. The victim must be a child less than 72 hours old. For this specific crime, the legitimacy or illegitimacy of the child is entirely immaterial to the charge. This raises a complex question regarding complicity. What exactly happens when a stranger helps a parent kill a newborn infant? The jurisprudence in People v. Echelus splits the liability based on relationship. The parent commits infanticide, but the stranger, lacking that specific blood tie, is liable for murder or homicide, depending on the circumstances of the act. In these categories, relationship and age parameters operate as automatic legal elevators. They immediately override the standard rules of circumstantial evidence. There is, however, one final mechanism that can disrupt this entire structure: the specific penalty substitute found in Article 247, governing death under exceptional circumstances. We need to correct a major professional misconception here. Article 247 does not actually define a felony. A prosecutor cannot charge someone with an Article 247 violation. They must still formally charge the accused with parricide or murder. Instead, Article 247 acts as an absolutory cause, or a penalty substitute, that the defense is responsible for proving in court. The trigger is highly specific: a legally married person or a parent catching their spouse or minor daughter in the act of sexual intercourse with another person. But the absolute temporal constraint is what dictates the outcome. The killer must surprise them in the act, and the lethal violence must be inflicted immediately thereafter. If the defense proves these conditions, the penalty substitution is drastic. Instead of facing reclusion perpetua, the penalty drops to destierro, or banishment. The philosophical justification for destierro is that it is not intended as a punishment. It exists to physically remove the killer from the vicinity, protecting them from retaliatory violence by the deceased's family. But if the facts deviate slightly, the override completely fails. As seen in People v. Bituanen, if the killing is delayed or occurs after merely finding the pair sleeping, Article 247 cannot be applied. Article 247 acts as a rigidly defined spatial and temporal safe harbor. Miss that exact window of action by a single minute, and the defendant faces life in prison. When analyzing any destruction of life scenario, the facts must be run through this algorithm in strict sequential order. Step 1. Check the victim's identity. You must determine if there is a legitimate spouse, a direct relative, or a victim under 72 hours old. Step 2. Check the circumstances. Does the evidence reveal that the killing was attended by treachery, evident premeditation, or poison? Step 3. Check the override. Do the rigid, immediate parameters of Article 247 apply to the facts? Step 4. If all these branches fail and no specific conditions are met, the charge defaults to the baseline offense. Mastering this taxonomy prevents fatal misclassifications in the courtroom. It ensures that the legal practitioner is guided by rigid statutory logic.
This video is about parricide, covered under Article 246 of the Revised Penal Code, as restored by Section 5 of Republic Act No. 7659. The elements of parricide are that a person is killed, the deceased is killed by the accused, and the deceased is related to the accused in the manner specified by law. Relationship is an essential element of the crime. The specified relationships include direct blood relatives, such as a father, mother, or child, whether legitimate or illegitimate. A child must be not less than 3 days old, otherwise the crime is infanticide. The relationship also includes other legitimate descendants and legitimate ascendants, excluding those already mentioned. Furthermore, it includes a legitimate spouse. Killing a third wife is not parricide if the first wife is legitimate, unless the subsequent marriage is valid under the Code of Muslim Personal Laws. Killing a woman the accused merely lived with is homicide. The best proof of relationship is a marriage certificate. However, an admission by the accused that they were married to the deceased, being against penal interest, is admissible to prove the required relationship. Notably, this relationship must be alleged in the information. An accused in parricide may be ordered to indemnify the heirs of the deceased, though indemnity may be denied if the accused is a presumptive heir. Parricide through reckless imprudence is a special case. This is demonstrated in the case of a husband who killed his wife while struggling with their children over a gun, distinguishing it from an intentional unlawful act. Parricide through reckless imprudence must be distinguished from parricide through simple imprudence or negligence. Parricide by mistake still constitutes parricide, but Article 49 of the Revised Penal Code applies. Article 246 requires a relationship between the offender and the victim, but not necessarily the knowledge of that relationship. Strangers cooperating in parricide are liable for homicide or murder, depending on the circumstances. Parricide is not punishable by reclusion perpetua to death when committed through negligence, by mistake, or under exceptional circumstances as defined in Article 247 of the Revised Penal Code. Next, we examine death or physical injuries inflicted under exceptional circumstances, governed by Article 247 of the Revised Penal Code. This can be justified if the person acts in a justified burst of passion. The penalty, when resulting in death or serious physical injuries, is destierro, which is not intended as punishment, but rather to remove the killer's spouse from the vicinity. If the result is merely less serious or slight physical injuries, it is an absolutory cause. The requisites for applying Article 247 concern a legally married person or a parent surprising their spouse or daughter in the act of sexual intercourse with another person. The daughter must be under 18 and living with the parent. Surprising a common-law wife does not fall within Article 247. The parent need not be legitimate. The daughter only needs to be under 18 and living with the parents. The daughter must be single or unmarried. If married, only her husband is entitled to the benefits of Article 247. A wife surprising her husband under these circumstances is also entitled to the benefits. Surprise is defined as coming upon them suddenly and unexpectedly. An attack initiated from preparatory acts to the actual commencement of sexual intercourse can still be considered, quote, by surprise. Surprising the act, or immediately thereafter, is essential. The sexual act itself must be witnessed or circumstances must reasonably show it was committed. Sexual intercourse is limited to the carnal act itself and excludes preparatory acts, although dissenting opinions argue this is too narrow an interpretation. The person must kill any or both of them, or inflict serious physical injury in the act or immediately thereafter. The continuous act includes the discovery, escape, pursuit, and killing. Killing the deceased outside the window after they were first wounded during the sexual act and then pursued is considered a continuous act. The killing must be a direct byproduct of rage, motivated by the blind impulse of the outrage, not external factors, and proximity in time is required. The element of surprise is lost if the accused merely upbraids the wife and tells her to leave the house. Article 247 does not apply if the spouse was a victim of sexual intercourse against her will. Finally, the accused must not have promoted or facilitated the prostitution of the wife or daughter, or consented to the infidelity of the other spouse. Article 247 does not define and penalize a felony. Destierro substitutes for the severe penalties of parricide, homicide, or serious physical injuries under the applicable articles of the Revised Penal Code. The prosecution must charge the accused with parricide, homicide, or serious physical injuries, while the defense must invoke and establish the requisites for Article 247. The court must receive evidence on surrounding circumstances. There is no liability for physical injuries suffered by third persons, as the act of inflicting death under exceptional circumstances is not considered a crime. We now discuss murder, covered by Article 248 of the Revised Penal Code, as amended by Republic Act No. 7659. Key amendments include changes to the penalty and the phraseology of Subdivision 3 concerning derailment or assault upon a railroad. The elements of murder require that a person was killed, specifically a, quote, person, under Article 248, and that the killing was done with intent to kill. However, if treachery was used, the killing is still considered murder, even without intent to kill, according to People v. Kagoko. Furthermore, the crime can be classified as attempted or frustrated murder if the victim is not killed. Another element is that the accused killed the deceased, and the killing was attended by any of the qualifying circumstances mentioned in Article 248. Regarding qualifying circumstances, only one is required for murder. Additional circumstances, if present, are treated as generic aggravating factors. An exception applies when a circumstance is absorbed or included within the qualifying one, and thus not appreciated even as generic, such as treachery absorbing abuse of superior strength. Qualifying circumstances must be alleged in the information. The older rule of treating unalleged but proven qualifying circumstances as generic aggravating factors is no longer authoritative under the 2000 Revised Rules on Criminal Procedure. Moreover, Article 248 is not the exclusive source for qualifying circumstances, as laws like the Comprehensive Dangerous Drugs Act can also provide for them. The qualifying circumstances under Article 248, Subdivision 1, include treachery. Treachery is characterized by sudden and unexpected shooting of victims not in a position to defend themselves, or when the act is done with no risk to the accused. Treachery presupposes that the means, methods, or forms of attack are consciously adopted. However, the mere killing of a child of tender age is murder, even if the manner of attack is not shown. Other circumstances in Subdivision 1 include taking advantage of superior strength and with the aid of armed men. Superior strength must be actively taken advantage of. Further circumstances under Subdivision 1 include employing means to weaken the defense, such as throwing a cloak over the victim's head. The participation of armed men must concur with the accused availing or relying on their aid. Subdivision 1 also includes employing means to ensure or afford impunity, such as covering one's face to prevent recognition or detection. This also includes employing persons to ensure or afford impunity. Subdivision 2 covers killing in consideration of a price, reward, or promise. When alleged, both the principal by induction and the principal by direct participation are guilty of murder. Subdivision 3 includes killing by means of inundation. Other means under Subdivision 3 include killing by means of fire, which requires the actual design to kill, and the purposeful adoption of fire as the means. Also covered is killing by means of poison, where the accused had the intent to kill and used the poison as the means. Murder by poison absorbs treachery and evident premeditation, preventing their appreciation as generic aggravating circumstances. The use of poison is inherent in murder only when the offender intended to kill and used poison as the means to achieve it. Confusion arises when poison is used for another purpose, but results in death. Subdivision 3 also covers killing by means of explosion, shipwreck, stranding of a vessel, derailment, assault upon a railroad, fall of an airship, motor vehicle, or the use of any other means involving great waste and ruin. Subdivision 4 refers to killing on the occasion of a public calamity, such as an earthquake, a volcanic eruption, a destructive cyclone, an epidemic, or other public calamity. Advantage must be taken of the occasion for this circumstance to apply. Subdivision 5 includes killing with evident premeditation. The elements of proof for evident premeditation are the time when the offender conceived the intent to kill, an act by the offender indicating they clung to that determination, and a sufficient lapse of time between the determination and the execution of the killing. Finally, Subdivision 6 covers killing with cruelty by deliberately and inhumanly augmenting the suffering of the victim, or outraging or scoffing at their person or corpse. This requires the deliberate infliction of wounds not necessary to kill, and the victim must have been alive when the wounds were inflicted. Within Subdivision 6, outraging implies an extremely vicious or deeply insulting act, as seen in cases like People v. Butler and People v. Carmina. Scoffing means to jeer, showing irreverence, such as hanging removed intestines around a victim's brother's neck in People v. Carmina. A final requirement for murder under Article 248 is that the killing is neither parricide nor infanticide. This means the act must not fall under Article 246 for parricide, nor Article 255 for infanticide. We now transition to homicide, defined in Article 249 of the Revised Penal Code as the unlawful killing, which is neither parricide, murder, nor infanticide. The elements include the penalty prescribed and the required elements for the offense. A key element is that a person is killed, which can involve attempted or frustrated stages. Regarding the element of a person being killed, the fact of death, or corpus delicti, must be established. For example, if a body disappears, the fact of death may not be sufficiently proven, as seen in U.S. v. Samarin. However, if circumstances indicate survival was impossible, corpus delicti may be sufficient, such as when the victim's limbs are tied before being thrown into the sea. Another element of homicide is that the accused killed the deceased without any justifying circumstance. This means the situation must not fall under Article 12, which defines justifying circumstances, or Article 247 for death under exceptional circumstances. Refusal of the injured party to undergo an operation is not a valid defense. The elements also require the accused to have the intent to kill, which is presumed when death results. Evidence of intent to kill is crucial for attempted or frustrated homicide. The intent must be proven beyond reasonable doubt. Finally, the killing must not be attended by any qualifying circumstance of murder, parricide, or infanticide. Special topics in homicide include the liability of two persons acting independently in killing one person. If both wounds were sufficient to cause death, and there was no conspiracy, both may be liable for homicide, as noted in People v. Abiog and Abiog. Homicide is not negatived if a mortally wounded victim commits suicide, provided the initial wound contributed to the death, as per People v. Lewis. Accidental death, resulting from a lawful act performed with proper care, is distinguished from homicide through imprudence or negligence. Finally, we consider the penalty for frustrated parricide, murder, or homicide under Article 250, Revised Penal Code. This article prescribes a penalty 1 degree lower than that imposed under Article 50 for the frustrated offense. Article 250 is permissive, not mandatory, allowing for the application of mitigating circumstances. We continue to discuss the criminal law pertaining to death caused in a tumultuous affray, as per Article 251 of the Revised Penal Code. This includes penalties and elements of the crime, under Title 8, Crimes Against Persons. The elements of death caused in a tumultuous affray start with there being several persons involved. A tumultuous affray requires at least 4 participants, and these persons must not be organized groups with a common purpose to assault each other reciprocally. Tumultuous affray is distinct from fights between well-known groups united for a common purpose to attack, where there is no confusion and aggression. The elements also require that several persons quarreled and assaulted one another in a confused and tumultuous manner. A key element is that someone was killed in the course of the affray, and the person killed need not be a participant. Importantly, it cannot be ascertained who actually killed the deceased. If the person inflicting the fatal injury is identified, the crime is homicide under Article 249, not Article 251. Serious physical injuries, if inflicted by one of the participants, should not be the cause of death. If the person who inflicted serious physical injuries or used violence can be identified, those participants are liable for the death, while others who only used violence are liable for their particular acts. The persons liable for death caused in a tumultuous affray are the individual or individuals inflicting serious physical injuries, if known. If that category is unknown, all persons who used violence upon the victim are liable. Next, we examine physical injuries inflicted in a tumultuous affray under Article 252. The penalties are 1 degree lower than that for the physical injury inflicted when the persons are unknown, but all who used violence are identified. For less serious injuries, the penalty is a resto menor of 5 to 15 days. The elements for physical injuries in a tumultuous affray are: a tumultuous affray occurred, and a participant suffered serious or less serious physical injuries. Only serious physical injuries are inflicted, means no person was killed. The injuries must be inflicted upon participants, unlike Article 251, which can apply to strangers. For physical injuries under Article 252, the person responsible for the injuries cannot be identified. All those who appear to have used violence upon the victim are known. There is no penalty for slight physical injuries in a tumultuous affray. Moving on to giving assistance to suicide, Article 253 outlines the penalties. Assisting another to commit suicide refers to merely furnishing the means. If suicide is consummated, the penalty is prison mare. If not consummated, the penalty is arresto mare in its medium and maximum periods. Lending assistance to the extent of doing the killing himself results in reclusion temporal if suicide is consummated, as it is practically homicide. If not consummated, the penalty is 1 or 2 degrees lower than the consummated suicide. Relationship is immaterial in this crime. A person attempting to commit suicide incurs no criminal liability. Attempting suicide is not an unlawful act for purposes of abortion liability. Assistance to suicide is distinct from euthanasia, or mercy killing, which is not lending assistance to suicide but may constitute murder. Discharge of firearms, under Article 254, has its own penalty and elements. The first element is that the offender discharges a firearm against or at another person. The discharge must be directed precisely at the offended party, not merely at random towards a house. The crime may still be committed, even if the gun was not pointed at the offended party when it fires, as long as it was initially aimed at them. Firing by a public officer in the air to capture gamblers and prevent escape is not a crime under this article. The offender must have no intention to kill, otherwise it may be attempted or frustrated parricide, murder, homicide, or infanticide. If the purpose is only to intimidate or frighten, the crime is likely a discharge of a firearm. The second form of discharge of firearms, incorporated by Republic Act No. 11,926, involves an offender discharging a firearm or similar device without intent to kill, acting willfully and indiscriminately. Being a member of military or law enforcement agencies, with the discharge not in the performance of official duties, qualifies the offense, increasing the penalty. Discharge of firearms can be complexed with serious or less serious physical injuries if the offended party is hit and wounded, as seen in jurisprudence like U.S. v. Marasigan. However, if the discharge results only in slight physical injuries, there is no complex crime, as slight physical injuries is only a light felony under Article 48 of the Revised Penal Code. Moving to infanticide, Article 255 of the Revised Penal Code, as amended, outlines the penalties. Generally, the penalty is the same as that for parricide or murder, but the crime is always called infanticide. This is discussed concerning scenarios where the accused is the father or mother of the child, generally. If the accused is the mother killing the child to conceal dishonor, this can serve as a reason for mitigation, suggesting a lack of time to reflect. However, a delinquent mother must be of good reputation to be entitled to this lesser penalty. Penalties for infanticide also apply when the accused is a legitimate grandparent of the child, both generally and to conceal dishonor, with the latter possibly mitigating. If other persons kill the child, the penalty is for murder, even if the stranger cooperated merely to conceal the dishonor. The elements of infanticide include that a child was killed, and it must have been born alive. The prosecution must prove the mother gave birth to a living creature. Alive means the child can sustain independent life. Further elements of infanticide are that the deceased child was less than 3 days old when killed by the accused. Concealing dishonor is not an element, but a mitigating circumstance, available only to the mother and maternal grandparents of the child. We now discuss intentional abortion under Article 256. Penalties depend on the manner of commission, using violence upon a pregnant woman, acting without violence and without the woman's consent, or acting with the consent of the pregnant woman. Abortion is the willful killing of the fetus in the uterus or its violent expulsion, resulting in death, distinguishing it from infanticide. The elements require a pregnant woman. The fetus can be over or less than 6 months old, but is typically before the 6th month or term of viability. The fetus is usually one not capable of sustaining independent life. However, even if full term, if it dies from violence or drugs, abortion still exists. Another element is the use of violence, administering drugs or beverages, or other acts upon the pregnant woman. As a result of the accused's actions, the fetus dies in the womb or after expulsion, resulting in a consummated, frustrated, or attempted crime. It is consummated when the fetus dies, frustrated when the fetus does not die despite all acts of execution performed, and attempted otherwise. Another element is the intention of the abortion. If abortion is not intended and the fetus doesn't die, the crime may only be physical injuries, as frustrated unintentional abortion does not exist. Persons liable for intentional abortion include those who cause it without consent, or by using violence, or without violence. For consented intentional abortion, the person who caused it and the pregnant woman who consented are liable, whether violence was used or not. The specific articles applicable vary depending on the use of violence and consent. Unintentional abortion under Article 256 has its own penalty and elements. The first element is the presence of a pregnant woman. The accused's lack of knowledge of the pregnancy is immaterial, as seen in U.S. v. Jeffrey, where maltreatment causing miscarriage led to liability for both. The second element requires that violence is used upon the pregnant woman without intending an abortion. Unintentional abortion is committed only by actual physical force or violence. Fear or fright causing abortion, without physical force, is not unintentional abortion. The third element of unintentional abortion is that violence is intentionally exerted. The case of U.S. v. Jeffrey shows an accused was found guilty for striking a pregnant woman, causing miscarriage. If there is neither intent to cause abortion nor violence, no abortion of any kind is committed. Reckless imprudence resulting in unintentional abortion or unintentional abortion through imprudence can occur, such as in People v. Jose, where a reckless driver caused an abortion. Unintentional abortion can also be a complex crime with homicide or parricide if violence is involved. Next is abortion practiced by the woman herself or by her parents, detailed in Article 258. Penalties apply to a woman practicing abortion upon herself or consenting to it. Generally, the woman is liable under one article, while the person causing the abortion is liable under another. Abortion to conceal dishonor is a mitigated offense for the woman. If the abortion is performed by the woman's parents with her consent, the penalty is similar to consented abortion to conceal dishonor. If the parents act without the woman's consent, it falls under a different article. The elements of Article 258, abortion by the woman herself or her parents, require a pregnant woman who suffered an intended abortion. The abortion must be caused by the pregnant woman herself, or by any other person with her consent, or by her parents with her consent, for purposes of concealing her dishonor. Abortion practiced by a physician or midwife and the dispensing of abortives are covered by Article 259. When practiced by a physician or midwife, the penalty for intentional abortion is imposed in its maximum period, reflecting the heavier guilt for misusing scientific knowledge. The elements for abortion practiced by a physician or midwife include: the offender is a physician or midwife, they cause or assist in causing abortion, and they take advantage of their scientific knowledge or skill. If no advantage of scientific knowledge is taken, a different article applies. Article 259 also covers dispensing abortives without a proper physician's prescription. The elements for this offense are that the offender is a pharmacist, dispenses any abortive, and does so without a proper prescription from a physician. Absence of knowledge that the abortive would be used to cause abortion is immaterial for this offense, as the act of dispensing without a proper prescription is punished. However, if the pharmacist knows the abortive will be used for abortion, they may face greater liability as an accomplice. Republic Act No. 4729 regulates the sale and distribution of contraceptive drugs and devices. It is unlawful to sell, dispense, or distribute them unless by a duly licensed drugstore or pharmaceutical company. Penalties include a fine or imprisonment, or both. Switching to dueling, Article 260 covers the responsibility of participants. A duel is a preconcerted, formal combat between two parties, with seconds, who select the arms and fix conditions. Penalties apply for killing one's adversary, which is the same as for homicide. Inflicting physical injuries in a duel results in the penalty for the corresponding physical injury, even if the agreement was to fight to the death. Making combat without inflicting physical injuries also carries a penalty. Slight physical injuries in a duel result in arresto menor. The persons liable in a duel as principals are those who killed, inflicted physical injuries, or both combatants in any other case. Seconds in the duel are considered accomplices. Challenging to a duel is penalized under Article 261. The punishment is one penalty for 3 acts: challenging another to a duel, inciting another to challenge or accept a challenge, and publicly scoffing at someone for refusing a challenge. A mere challenge to fight without contemplating a formal duel is not considered challenging to a duel under this article. The persons liable include the challenger and instigators. This is a unique case where mere provocation to commit a crime is punishable. This video examines mutilation under Article 262 of the Revised Penal Code. Mutilation is defined as the lopping or clipping off of body parts, excluding the putting out of an eye. The penalties are based on two kinds of mutilation, starting with intentionally depriving another of an essential organ for reproduction. The elements for the first kind of mutilation, castration, require the removal of organs necessary for generation, such as the penis or ovary. The act must be done purposely and deliberately to deprive the offended party of this essential organ for reproduction. The second kind of mutilation involves intentionally making other mutilations by lopping or clipping off body parts other than essential organs for reproduction to deprive the victim of those body parts. This act, also known as mayhem, requires the mutilation to be intentional and involve non-reproductive body parts. We now discuss serious physical injuries under Article 263. This offense can be committed by wounding, beating, assaulting, or administering injurious substances. The intent to kill is not present in serious physical injuries. The penalties for serious physical injuries are categorized based on three factors: consequences of injuries inflicted, nature and character of the wound, and the proper penalty. The first category is when the injured person becomes insane, imbecile, impotent, or blind. Under this first category, impotent means the inability to copulate and sterility. Blindness under Subdivision 1 of the Revised Penal Code must involve both eyes and must be complete, not just a mere weakness of vision. The second category of serious physical injuries includes loss of the use of speech, or the power to hear or to smell. It also covers the loss of a principal member of the body, such as an eye, hand, foot, arm, or leg, or the loss of use of such a member. Finally, it covers becoming incapacitated for one's habitual work. Subdivision 2 of Article 263 refers to principal members of the body, such as an arm. The third category covers the injured person becoming deformed, losing any other non-principal body member, losing the use of such member, or becoming incapacitated for work for more than 90 days. Deformity refers to permanent and definite physical ugliness that is conspicuous and visible. Deformity requires physical ugliness that constitutes a permanent and definite abnormality. Loss of an upper central incisor impaired appearance and constituted disfigurement not removable by action of nature. Artificial teeth do not repair the injury resulting from the loss of front teeth. For deformity to be present, it must be conspicuous and visible. Loss of both outer ears involves deformity. Loss of a lobule of the left ear is considered a deformity. Loss of the index and middle finger is either deformity or loss of a non-principal member. Loss of the power to hear of only one ear is considered the loss of use of another body part. Illness is for a certain period of time when the wound inflicted did not heal within that period, lasting more than 30 days. Medical attendance is not essential in serious physical injuries, only the illness or incapacity for labor. Subdivision 3 covers body members not considered principal members, such as fingers. Loss of use of 3 fingers of the left hand is a serious physical injury under Subdivision 3. A front tooth is considered a member of the body. The fourth category is when the injured person becomes ill or incapacitated for labor for more than 30 days, but not more than 90 days. Incapacity for work under Subdivisions 2 and 3 refers to work habitually performed. However, Subdivision 4 speaks of incapacity for any kind of labor. Any injury requiring hospitalization for more than 30 days is a serious physical injury under Subdivision 4. Evidence of the length of the period of illness or incapacity for labor is essential, where the category of offense depends on such period. Mere lessening of efficiency is not incapacity. Physical injuries presuppose no intent to kill. Otherwise, the crime is frustrated or attempted murder, parricide, or homicide. Physical injuries differ from homicide because, in physical injuries, there is no intent to kill, whereas attempted or frustrated homicide involves an intent to kill. We continue with serious physical injuries under Article 263. Qualified physical injuries are covered in the paragraph next to the last. This includes relationships enumerated in Article 246, defining parricide, except for serious physical injuries by excessive chastisement by parents. Qualified physical injuries also cover circumstances specified in Article 248, which defines murder. The elements of the offense, administering injurious substances or beverages, under Article 264, include inflicting serious physical injury and doing so by knowingly administering injurious substances or taking advantage of the victim's weakness of mind or credulity. No liability exists under Article 264 if the accused did not know the injurious nature of the substance. Administering injurious substance means introducing it into the body. Throwing chemicals on the face is not considered administering under Article 264. Taking advantage of weakness of mind or credulity may occur in cases of witchcraft or philters. Next, let's discuss less serious physical injuries under Article 265. The penalties for simple, less serious physical injuries apply when the offended party is incapacitated for work for 10 days or more, but not more than 30 days, or requires medical attendance for the same period. Medical attendance or incapacity are alternative conditions. Without medical attendance or incapacity for labor, the crime is only slight physical injuries. The requirement for medical attendance must prove the required period. The physical injuries must not fall under Articles 262, 263, and 264 of the Revised Penal Code. Importantly, the offender must have no intent to kill. Qualified less serious physical injuries fall into two categories. The first involves a manifest intent to insult or offend the injured person or circumstances, adding ignominy to the offense. The second category of qualified less serious physical injuries involves the victim being the offender's parents, ascendants, guardians, curators, or teachers. It also includes cases where the victim is a person of rank or authority, provided the crime is not direct assault. If there was intent to kill, the crime is frustrated murder. Slight physical injuries are covered under Article 266, and the penalties are specified therein. There are three kinds of slight physical injuries. The first is physical injuries that incapacitate the offended party for labor or require medical attendance for 1 to 9 days. The second type of slight physical injuries covers cases that did not prevent the offended party from working or require medical attendance. The third category is ill treatment of another by deed without causing any injury, involving physical violence that does not produce injury. Slight physical injuries apply when there is no evidence of actual injury or no proof of the period of incapacity for labor or required medical attendance. A supervening event that converts the crime to serious physical injuries after filing may still be subject to a new charge. Next, we discuss Republic Act No. 8049, which regulates hazing and other forms of initiation, now amended by the Anti-Hazing Act of 2018, Republic Act No. 11053. The new act defines hazing and organization and regulates initiations. The penalties for hazing have been significantly increased by the Anti-Hazing Act of 2018. If death, rape, sodomy, or mutilation results from hazing, the penalty is reclusion perpetua and a fine of 3 million pesos. Participants and officers present are also subject to severe penalties. All persons present during hazing face a penalty of reclusion temporal maximum and a fine of 1 million pesos. Former officers who obstruct investigation face reclusion temporal and a 1 million peso fine. Persons using intimidation for recruitment face prison correctional minimum. Other provisions include a fine of 1 million pesos for hazing during school-approved rites without a school representative present. Salient provisions also cover the criminal and administrative liability of owners, school authorities, and barangay officials. The Anti-Hazing Act of 2018 includes several important rules: a prima facie presumption of participation from mere presence, joint liability of incumbent officers, and non-availability of lack of intent as a mitigating circumstance. Penalties also apply to corporate officers involved in hazing for employment, and convictions must be reflected in records. We are now moving on to rape under Article 266A of the Revised Penal Code, as amended. This falls under Title 8, Crimes Against Persons, Chapter 3. We will discuss when and how rape is committed, including its two modes and the applicable penalties. Rape, as amended by Republic Act No. 8353, is punishable with reclusion perpetua to death under certain conditions. This includes when rape is committed with the use of a deadly weapon or when committed by 2 or more persons. Regarding multiple rape committed by 2 or more offenders, judicial decisions indicate that each accused can be held responsible for multiple rapes, based on their personal acts or through the finding of conspiracy. Circumstances where rape is punishable with reclusion perpetua to death also include cases where the victim becomes insane by reason or on occasion of the rape, or when attempted rape is committed and homicide results. Rape is punishable by death when the victim is under 18 years of age, and the offender has a specified relationship with the victim, such as a parent, ascendant, step-parent, guardian, or certain relatives by consanguinity or affinity, or the common-law spouse of the parent. The death penalty also applies when the victim is under the custody of police, military authorities, other law enforcement authorities, or a penal institution. These cases must be distinguished from those where the offender is a member of such organization. Another circumstance for the death penalty is when rape is committed in the full view of specified relatives of the victim, including a spouse, parent, children, or relatives within the third degree of consanguinity. Rape is also punishable by death if the victim is a religious person, provided they are engaged in a legitimate religious calling, personally known to be such by the offender, and this knowledge existed at or before the time of the rape. The death penalty also applies when the victim is a child below 7 years old. Additionally, if the offender knows they are afflicted with HIV/AIDS and the virus or disease is transmitted to the victim, it is also punishable by death. If the offender knows they are afflicted with any other sexually transmissible disease and transmits it to the victim, it is punishable by death. The death penalty also applies if the offender is a member of the armed forces or the Philippine National Police and takes advantage of their position. Additional grounds for the death penalty include when the offender is a member of any law enforcement agency or penal institution and takes advantage of their position. Finally, if the victim suffers permanent physical mutilation or disability because of the rape. Another circumstance for the death penalty is when the offender knew of the victim's pregnancy at the time of rape. This also applies when the offender knew of the victim's mental disability, emotional disorder, or physical handicap at the time of the offense. Rape complexed with other crimes is punished as a special complex crime. Attempted rape with homicide is punishable with reclusion perpetua to death. Note that the law no longer includes frustrated rape with homicide. Rape with insanity is punishable with reclusion perpetua to death if the victim became insane by reason or on occasion of the rape. Note that the law does not state when insanity results as a consequence of rape. Rape with homicide is punishable with death when, by reason or on occasion of the rape, homicide is committed. Homicide committed by reason or on occasion of rape is a special complex crime, as seen in cases like People v. U. We continue to discuss the definition of rape under Article 266A of the Revised Penal Code, as amended by Republic Act No. 8353. One of the essential elements is that the offender, who is a person, must have carnal knowledge of another person. Rape of the first kind can only be committed by male persons capable of penetration, even if they are impotent or a minor. This type of rape requires sexual intercourse. Otherwise, it may be rape of the second kind or only acts of lasciviousness. Penetration, however slight or partial, is necessary for rape. Proof of omission is not required, and the absence of spermatozoa does not negate rape. Furthermore, the character of the offended woman is immaterial and not a defense. The act must be accomplished under circumstances of force, intimidation, or threat, as enumerated in Article 335 of the Revised Penal Code. The required degree of force is a manifest and tenacious resistance, taxing the victim's powers to the utmost, not just a mere verbal refusal or initial resistance. The force need not be irresistible, but must be present and sufficient to achieve the culprit's purpose of copulating. Resignation to a consummated act is not considered consent, especially if the victim was asleep when the act began. Intimidation includes moral coercion, such as fear caused by a threat with a weapon. Additionally, moral ascendancy or influence of the accused over the victim can substitute for determined resistance, especially in cases involving a father and a daughter of tender age. Rape can also be committed if the woman is deprived of reason or otherwise unconscious. This includes victims deprived of reason, such as those who are insane, feeble-minded, or idiotic, as long as the mental abnormality or deficiency is sufficient. Victims who are unconscious, such as those asleep, in a lethargy, or knocked unconscious by a blow, are also covered. Administering a narcotic or potion that deprives the woman of reason and will to resist constitutes rape. Rape can be committed through fraudulent machination or grave abuse of authority. Additionally, the act constitutes rape if the offended party is under 16 years of age or demented, even if force or intimidation is absent. There is an exception for consensual, non-abusive, and non-exploitative acts if the age difference is not more than 3 years, and the victim is 13 years of age or older. Non-abusive means the absence of undue influence, intimidation, or harm during sexual activities. Non-exploitative means there is no actual or attempted act of unfairly taking advantage of the child's vulnerability, differential power, or trust. Consent is immaterial in the case of rape of a woman under 13 years of age. Carnal knowledge of a victim under 13, even if consensual, is still considered rape under the law. Rape is consummated even if penetration is only slight, such as penetration of the labia of the female organ. Complete, full, or perfect penetration is not essential. Rupture of the hymen is also not required, and absence of spermatozoa does not disprove consummation. The stage of frustrated rape is considered a, quote, dead provision. An act is considered only attempted rape if there is no penetration of the female organ, or only acts of lasciviousness if there is no penetration but other sexual acts were performed. Rape is considered attempted if there is no penetration. Traditionally, a husband cannot be held guilty of raping his wife due to matrimonial consent. However, Article 266A, as amended by Republic Act No. 8353, addresses situations where the offender is the legal husband. In the case of People v. Jumawan, the court found a husband liable for 2 acts of rape committed against his wife. This ruling applied the, quote, by a man clause of Article 266A, read together with the second paragraph of Article 266C. There are exceptions where a husband can be found guilty of rape against his wife. This occurs if they are legally separated, and he forces her to submit to sexual intercourse, or if the husband acts as a principal by induction, indispensable cooperation, or accomplice in the rape of his wife. Other non-consented forms of sexual assault are covered under Article 266A, as amended, where either the offender or the offended party can be, quote, any person. This includes 2 types of second-kind rape involving oral and anal insertion, which can only be committed by a male offender. The penalties for rape, under Article 266B, depend on the kind and circumstances of the offense. Simple rape of the second kind is punishable with prison mayor. Qualified rape of the second kind is punishable with prison mayor to reclusion temporal, particularly when committed with a deadly weapon or by 2 or more persons. Multiple rape of the second kind committed by 2 or more offenders is addressed in case law, holding each accused responsible for the rapes committed personally and by others if based on a finding of conspiracy. Rape of the second kind is punishable with reclusion temporal if the victim becomes insane as a result of the act. It is punishable with reclusion temporal to reclusion perpetua if attempted rape of the second kind is committed and homicide results by reason or on occasion thereof. Rape of the second kind is punishable solely with reclusion temporal if the victim is under 18 years of age and the offender is in a specified relationship, such as a parent, ascendant, step-parent, guardian, or relative within the 3rd civil degree of consanguinity or affinity. The penalty of reclusion temporal also applies if the victim is under the custody of the police, military authorities, other law enforcement authorities, or a penal institution. Distinction is made if the offender is a member of the mentioned authorities. Additionally, the penalty of reclusion temporal applies if the rape is committed in the full view of specified relatives of the victim, including a spouse, parent, children of the victim, or relatives within the 3rd degree of consanguinity. Reclusion temporal also applies if the victim is a religious, and the offender is personally aware of this fact before or at the time of the rape. It also applies if the victim is a child below 7 years old. The penalty of reclusion temporal to reclusion perpetua applies if the offender knows they are afflicted with HIV/AIDS or another sexually transmissible disease, and the virus or disease is transmitted to the victim. It also applies if the offender is a member of the Armed Forces of the Philippines or paramilitary units and takes advantage of their position to facilitate the crime. We continue to discuss rape of the second kind, as defined and committed under Article 266A of the Revised Penal Code, as amended by Republic Act No. 8353, particularly as regards its specific qualifying circumstances that relate to the offender's position, such as being a member of the Philippine National Police, any law enforcement agency, or any penal institution, and taking advantage of that position to facilitate the crime. Other circumstances include when the victim suffers permanent physical mutilation or disability due to the rape, or when the offender knew the victim was pregnant at the time. Also, if the offender knew the victim had a mental disability, emotional disorder, or physical handicap, it constitutes rape, distinguishable from the first kind where the victim is demented or deprived of reason. Rape of the second kind, complexed with other crimes, is punished as a special complex crime. This is punishable with reclusion temporal to reclusion perpetua. An example is attempted rape with homicide. Note that frustrated rape of the second kind with homicide is not recognized. Rape with insanity is punishable with reclusion perpetua to death. Rape of the second kind with homicide is punishable with reclusion perpetua. Homicide committed by reason or on occasion of rape is a special complex crime, relating to the principles for robbery with homicide. Homicide not committed by reason or on occasion of rape, such as when the victim was already at the threshold of death, is a point of distinction. Attempted rape of the second kind with homicide and rape with permanent physical mutilation or disability are also discussed under Art 266b. The elements of rape of the second kind begin with the offender committing an act of sexual assault on the victim. The offender can be any person, regardless of capability for penetration. The victim can also be any person, male or female, as penetration can involve any instrument or object. The offender may be male or female, although anal or oral insertion of the penis can only be committed by a male offender. Rape of the second kind does not require sexual intercourse, overlapping into acts of lasciviousness. Penetration or insertion into the mouth or anal orifice, however slight, is necessary. Proof of omission is not a requirement for rape of the second kind, meaning the absence of spermatozoa does not negate the crime. Furthermore, the character of the offended party is immaterial. Even an unchaste character, or being a prostitute, does not constitute a defense if the act was committed with force and violence. The sexual assault must be accomplished under any of the circumstances in Article 266a. One such circumstance is using force, intimidation, or threat. The required degree of force is a manifest and tenacious resistance, taxing the victim's powers to the utmost, not just verbal refusal or initial resistance. Force need not be irresistible, but must be present and sufficient to achieve the culprit's purpose. Force is a relative term, depending on the age, size, and strength of the parties. Resignation to the consummated act is not consent, such as when the victim was asleep and failed to resist upon waking. Intimidation includes moral fear, such as being threatened with a weapon, or through the moral ascendancy or influence of the accused over the victim. In cases involving a father and daughter, force or violence may not need to be of the same nature as required in other cases. The victim may also be deprived of reason or otherwise unconscious, meaning they have no will to resist. Deprivation of reason includes victims who are insane, feeble-minded, or idiotic, where mental abnormality is sufficient. However, a mere deaf-mute is not considered deprived of reason without proof of imbecility. A victim is considered unconscious if they are asleep, in a lethargy from sickness, administered narcotics, or knocked unconscious. However, consent induced by a drug that incites passions but does not deprive the victim of willpower is not rape. The third way to commit rape is by fraudulent machination, or grave abuse of authority. Rape is committed when the offended party is under 16 years of age or is demented, even if other circumstances are absent. An exception exists for those under 16 if the age difference is not more than 3 years, and the act is consensual, non-abusive, and non-exploitative, unless the victim is under 13 years old. Consent is immaterial in rape of the second kind for victims under 13 years of age. Case law confirms that rape can be committed, even if the victim consented to the sexual act, or was a prostitute under 12 years old, due to their age rendering consent invalid. Let's discuss the stages of execution for the second kind of rape. It is consummated with the penetration of the labia, anal orifice, or mouth. The slightest penetration is sufficient, and complete or perfect insertion is not essential. Rupture of the hymen is not required. There is no frustrated stage in the second kind of rape. However, attempted rape occurs if there is no penetration or insertion into the genital organ, anal orifice, or mouth. A husband can be guilty of this kind of rape committed on his own wife, according to Article 266c. Regarding penalties, rape of the first kind is governed by Article 266b. The penalty for rape of the second kind, also under Article 266b, is further detailed in the discussions under Article 266a, as all are amended by Republic Act No. 8353. Concerning the effect of pardon, for simple rape under Article 344, the penal action is extinguished, benefiting principals, accomplices, and accessories. For multiple rape, marriage with one defendant will extinguish criminal liability, but the benefit does not extend to co-principals. The effect of marriage between the offender and the offended party in rape is also covered by Article 266C. If the offender is the legal husband, forgiveness given after the rape extinguishes the criminal action or penalty. An exception is if the marriage was void ab initio. Article 266D establishes legal presumptions of non-consent. These include any physical overt act, manifesting resistance, and any condition that renders the victim incapable of giving consent. In the rules of evidence for rape, force and violence must be proven by strong evidence. However, rape can be proven by the uncorroborated testimony of the offended woman, provided it is conclusive, logical, and probable. Courts must scrutinize the complainant's testimony with extreme caution, as the accusation of rape is easy to make but difficult to disprove. The prosecution's evidence must stand on its own merits, independent of the defense's weakness. The Rape Shield under Republic Act No. 8505 disallows evidence of the victim's past sexual conduct, opinions on that conduct, or opinions on the victim's reputation, unless found to be material and relevant by the court. Welcome to this video on Crimes Against Persons, Title 8 of the Revised Penal Code of the Philippines. We will provide a visual synthesis of the jurisprudence and statutory elements. Title 8 covers a continuum of protection, from the right to existence to bodily autonomy. The critical differentiator across these crimes is the offender's specific intent, particularly the presence or absence of animus interficiendi, intent to kill. When corpus delicti and intent to kill are established, the destruction of life diagnostic tree guides the charge. The victim's relationship and age, as well as any qualifying circumstances, determine whether the crime is parricide, infanticide, murder, or homicide. Murder, Art 248, requires a qualifying circumstance. These circumstances relate to the method of attack, motivation, means of destruction, opportunism, timing, and inhumanity of the act. Article 247 outlines the sequence for death under exceptional circumstances. The actor must be a legally married spouse or a parent killing a daughter under 18 who is surprised suddenly and unexpectedly in the act of sexual intercourse. The result is asterisk destiero, a protective measure. Liability in a chaotic killing depends on whether the groups were organized, suggesting homicide or conspiracy, or if the actual killer cannot be ascertained within a tumultuous affray. The latter applies when 4 or more persons are involved in a confused assault and no organized group is present. The law distinguishes infanticide and abortion based on the age of the victim. Infanticide, or the killing of a child less than 72 hours old, applies to Zone 2. Outside this zone, other charges like parricide, murder, or homicide apply, while abortion is distinct and covers the killing of a fetus, time in utero. For physical injuries, the asterisk animus interficiendi is the divider. Absence of the intent to kill limits the crime to physical injuries, regardless of severity. Crimes like mutilation and administering injurious substances fall into the intent to injure category. Physical injuries are classified by severity. Serious injuries involve anatomical impairment or incapacity lasting more than 30 or 90 days. Less serious injuries last 10 to 30 days, and slight injuries require no medical attendance and last 1 to 9 days. The Anti-Hazing Act, RA 8049/RA 11053, mandates severe penalties, particularly when the hazing results in death, rape, sodomy, or mutilation. Legal standard states that mere presence raises a presumption of participation, and lack of intent is not a mitigating circumstance. Rape, Art 266A, follows a dual-mode framework. Mode 1 is carnal knowledge, rape of the first kind, involving penile penetration of the labia, strictly man to woman. Mode 2 is sexual assault, rape of the second kind, involving various forms of penetration or insertion, by any person to any person. Non-consent in rape is established by force, threat, intimidation, being deprived of reason/unconscious, fraudulent machination, or statutory age thresholds. Consent is immaterial if the victim is under 12 or under 16, with some exceptions for the latter age group. The severity of rape is escalated by elevated triggers, resulting in maximum penalties for qualified rape. Special complex crimes, such as rape with homicide, represent the most severe offenses in this category. Defenses, extinguishment, and evidence in rape are governed by specific rules. The Rape Shield Law disallows most evidence of the victim's past conduct. Extinguishment occurs through subsequent valid marriage. An uncorroborated testimony of the victim is sufficient for conviction if it is credible. The Title VIII Diagnostic Checklist summarizes the key steps in assessing crimes against persons, focusing on establishing corpus delicti, assessing intent, mapping relationships, verifying age and time thresholds, and auditing for qualifying circumstances.
Welcome to The Explainer. Today we're going to completely demystify something absolutely fascinating: how the justice system precisely, and sometimes really surprisingly, measures human harm. Have you ever wondered why two different crimes that result in the exact same physical outcome can carry wildly different penalties? Well, it's because the law doesn't just look at the injury itself. It looks at the intent, the method, and even the relationship between the people involved. We're going to unpack the meticulous, honestly, almost mathematical way the criminal code categorizes violence, mapping out our descent from the ultimate crime of taking a life, all the way down to a simple slap. Okay, let's dive into this. Here is our syllabus for today. 1. The hierarchy of harm. 2. Murder versus homicide. 3. Crimes in the family. 4. Chaos, duels, and firearms. 5. Degrees of physical injury. And finally, 6. The anti-hazing law. Let's get to it.
Section 1. The hierarchy of harm, when taking a life carries different weights.
To really understand criminal law, we first have to accept a fundamental premise. In the eyes of the court, not all deaths are weighed equally. Now, you might think the loss of human life is a singular, unchangeable tragedy, right? But legally speaking, the identity of the victim and their connection to the offender matters intensely. The law actually creates an escalation scale based entirely on relationship. And this brings us to a specific legal classification known as parricide. It operates on a very strict if-then scenario. If an offender kills a total stranger, well, that falls under one set of rules. But if they kill a legitimate spouse or a direct blood relative, we're talking a father, mother, or child, the law elevates the crime to parricide. It recognizes the profound breach of trust and the fundamental societal taboo of destroying your own family line.
Let's move to and see how this builds in Section 2, murder versus homicide, how the law categorizes unlawful killing.
So let's see what happens when we step outside the family unit. When a life is taken and it's not a direct relative, the law has to figure out exactly how to categorize that unlawful killing. The easiest way to think about this: homicide is your baseline. It's the unlawful killing of a person without any special malicious elements attached to it. It's tragic, absolutely, and it's a severe crime, but it's the standard. Murder, on the other hand, is an upgraded charge. It happens when that baseline killing is attended by specific aggravating circumstances that the law deems especially heinous. Basically, the scales tip when the offender's methods show a much deeper level of malice. Now, what's really interesting about this slide is just how specific these qualifying circumstances are. A standard killing literally transforms into murder if the offender uses treachery, meaning a sudden attack that leaves the victim absolutely no chance to defend themselves, ensuring zero risk to the attacker. Or consider evident premeditation. This is where the law looks for a sufficient lapse of time between planning the act and actually executing it, showing cold, calculated determination. Even the tools used matter. Utilizing poison, fire, or an explosion automatically upgrades the crime because it clearly shows a purposeful, destructive design. Moving right along to Section 3. Crimes in the family. Death under exceptional circumstances.
Now, the law isn't entirely blind to the sheer chaos of human emotion. Under Article 247, we find a fascinating exception in the criminal code where extreme justified passion momentarily alters the legal consequences of taking a life. But the logic here is incredibly strict. To qualify for this exception, an offender must be a legally married person or a parent. They must literally surprise their spouse or their daughter under the age of 18 in the very act of sexual intercourse with another person, and they have to commit the violent act right then and there or immediately after. The law requires the violence to be a direct byproduct of sudden, overwhelming blind rage. It has to be a proximate result of the outrage of that exact moment.
So if those incredibly strict conditions are met, the punishment isn't the standard prison time for taking a life. Instead, the penalty is distero. Now, that's an archaic legal term that essentially translates to banishment. And here is the truly fascinating quirk about this. Distero isn't strictly meant as a harsh penal punishment. Actually, Scratch that, it's more like a protective measure. It physically removes the killer's spouse from a specific geographic vicinity to protect them from acts of reprisal by the enraged relatives of the deceased. Section 4. Chaos, duels, and firearms. When the crowd gets violent. Transitioning away from targeted one-on-one killings. What happens when a whole crowd gets violent and the exact chain of events becomes literally impossible to untangle? Well, the law has a specific term for this too, a tumultuous affray. Think of a chaotic bar brawl or a massive, messy street riot. The legal requirements are that there must be at least 4 people involved, fighting in a confused and uncoordinated manner where someone ends up dead, and, this is crucial, the actual killer cannot be identified. If the courts simply can't figure out who delivered the fatal blow because of the sheer confusion, they apply the rules of a tumultuous affray to assign liability to those who used violence. And this brilliantly illustrates the contrast the law draws between different types of multi-person violence. On the left side, we have the tumultuous affray, spontaneous, messy, and totally uncoordinated. But on the right, we have a duel. A duel is the exact opposite. It is a preconcerted, formal combat between 2 parties, complete with witnesses or seconds who agree on the weapons and firmly fix the conditions of the fight. The law treats these 2 scenarios completely differently because the level of calculation and the structure of the violence are just worlds apart.
Okay, so far we've been talking about the destruction of life. But what happens if the victim survives? We need to completely reset our expectations as we descend the hierarchy of harm here. How exactly does the court measure an injury that doesn't result in death? Section 5. Degrees of physical injury. The meticulous maths of human harm. When there's no intent to kill, but physical harm is still done, the justice system relies on highly specific medical math to grade the severity of the offense. The court fundamentally looks at the calendar to decide how much trouble the offender is in. Notice how the severity is linked directly to the days of healing or incapacity for labor. If the injury requires 1 to 9 days to heal, it's categorized as slight physical injuries. If it takes 10 to 30 days, it escalates to less serious physical injuries. And if the victim is incapacitated for more than 30 days, or if they lose the use of a principal member of their body, it jumps right up to serious physical injuries. But sometimes it's not just about the days it takes to heal, you know? Sometimes it's about the permanent result. Here's a highly specific and honestly slightly humorous legal quirk. A fistfight that results in the loss of a single front tooth is often categorized at the absolute highest level, a serious physical injury. You might be wondering why. Well, because the law dictates that losing a front tooth creates a permanent, visible physical deformity that nature just cannot repair on its own. The visual impact literally upgrades the crime.
Moving to our final section, Section 6, the anti-hazing law, institutional violence and its consequences.
For our final syllabus topic, we have to look at how the law tackles institutionalized group violence. This is addressed through the anti-hazing law, specifically looking at fraternities, sororities, and similar organizations. Now, the Anti-Hazing Act of 2018 is designed to be a deterrent through sheer, overwhelming weight. If hazing results in death, rape, or mutilation, the penalty is reclusión perpetua, which is essentially life imprisonment, plus a 3 million peso fine. But notice how absolutely massive the net is that the law casts here. It's not just the person throwing the punch. Actual planners, participating members, and officers who are merely present face similar life sentences and massive fines. Even school authorities face administrative liability, and the owner of the venue where the hazing took place can face criminal liability. The whole shebang. So the crucial point here is this specific legal doctrine. Mere presence raises a prima facie presumption of participation. Put in plain English, if you are in the room while hazing is happening, the law presumes you are legally complicit. You cannot simply stand by and watch. The burden suddenly becomes yours to prove you weren't involved, which completely flips the standard dynamic to aggressively root out the specific type of institutional harm. As we step back and look at this entire hierarchy, from the strict definitions of murder and parricide to the medical math of physical injuries, all the way to the sweeping net of the anti-hazing law, it leaves us with a really profound question to ponder. Is the justice system ultimately measuring the physical harm done to the human body, or is it actually trying to measure the malicious intent hidden inside the human mind? The way the law perfectly balances the physical outcome with the psychological intent is what makes this topic so endlessly fascinating. Thank you so much for joining me for this explainer, and keep questioning the structures around you.
Imagine a man walks into a room.
Right.
And he commits just a horrific act of violence. He takes 2 lives.
Right.
One victim is the woman he's lived with for, say, 20 years. I mean, they share a home, a whole life together, everyday routine.
Yeah, real partnership.
Exactly. And the other victim is his own child. Now, to a normal person, to anyone with a pulse, really this is just a single, unspeakable tragedy. It's a shattered family.
Absolutely.
But to the Philippine Penal Code, this is a mathematical equation.
Yes, it is.
And the law is about to treat one of those deaths vastly, like almost incomprehensibly differently than the other. So welcome to you, the listener, to this deep dive. Today, we're going on a journey into this really dense, fascinating, and honestly, sometimes terrifying stack of legal notes.
It's quite a stack.
It really is. We're looking at the Philippine Criminal Law 2 Syllabus, and we're specifically focusing on Title 8, which covers crimes against persons.
And it's just such a profound document to examine, because when you read through a penal code, you aren't just looking at like a list of forbidden acts and their corresponding prison terms.
Right. It's more than that.
Much more. You are looking at the literal DNA of a society's morality. It's this highly precise mathematical calculation of human chaos.
Oh, I like that phrasing.
Yeah, I mean, it tells us exactly how much a culture values family or honor, bodily autonomy, fairness, down to the exact day a person will spend behind bars.
Right. And our mission today is to decode that DNA. We aren't just going to, sit here and read you a list of rules.
No, that would be incredibly boring.
Super boring. We want to understand the architecture of this morality.
Yeah.
We're going to explore the underlying logic, like the actual why behind these laws.
Exactly.
We'll journey from the absolute ancient taboo of killing a family member, navigate through the surprisingly rigid rules of formal duels.
Which is wild, by the way. So wild. And then to chart the modern ongoing evolution of sexual assault laws, our goal is to leave you with a completely new understanding of how the legal system categorizes violence.
And to do that properly, I think we really have to start with the most intimately devastating crimes imaginable.
Violence within the
Exactly. It's a universal human taboo. But the law, it draws this incredibly specific, rigid boundary around what actually constitutes the quote-unquote family when it comes to the ultimate crime, which is parricide. That's found under Article 246.
Okay.
The core legal question here is basically, how does the system treat you differently if you kill a blood relative versus just, a complete stranger on the street?
Well, it treats you significantly worse, right? I mean, the notes state the penalty for parricide is reclusion perpetua to death.
Right.
And just to clarify, for those of us who don't have a law degree hanging on the wall, what exactly does reclusion perpetua mean in practical terms? Is that basically just life in prison? Well, it's an important distinction to make. Reclusion perpetua, at least in the Philippine legal context, generally means an imprisonment of 20 to 40 years.
Okay, 20 to 40.
Yeah, after which a person might become eligible for pardon, though it does carry specific accessory penalties regarding the loss of civil rights. So it is a massive leap in severity from just standard homicide.
Wow, okay.
But the fascinating part of Article 246 isn't just the punishment itself. It's the precise boundary the law draws around the victim. Parricide isn't simply killing anyone you happen to be related to.
Right, it's specific.
Very. The law defines it strictly as killing a direct blood relative in the ascending or descending line, or your legitimate spouse.
Ascending or descending. So we were talking about your father, your mother, or your child.
Yes, and it specifies that it can be a legitimate or illegitimate father, mother, or child.
Oh, interesting.
Right, so the law recognizes the blood tie regardless of the parent's marital status at the time of birth. It also encompasses other legitimate ascendants, like, say, a grandfather, or descendants, like a legitimate grandchild.
Okay, that makes sense.
But here's where the legal boundaries get shockingly rigid. It completely excludes collateral lines.
Meaning siblings. Which, honestly, that just blew my mind when I read it.
It's surprising, isn't it? Precisely. If someone murders their brother or sister, it is undeniably a horrific familial tragedy. Like, nobody disputes that.
Of course not.
But legally, under the strict interpretation of this specific code, it is not parricide.
Wow.
It would be categorized as murder or homicide, depending on, how the act was actually carried out. The law reserves this specific ultimate category of betrayal parricide exclusively for the vertical bloodline and the legal spouse.
So siblings are out.
Siblings are out. And it also shuts out relationships by affinity. So killing a mother-in-law, for instance, is not parricide.
And I noticed in the notes it also excludes adoption.
Yes, it does.
Like if a legally adopted child kills their adoptive parent, Or vice versa. The syllabus basically implies that's not parricide either.
According to the strict interpretation of the legal text provided in these notes, that is absolutely correct.
That's intense.
It is. The relationship must be forged of direct blood, with the sole exception being the legitimate spouse. The legal fiction of adoption, while it's incredibly strong in civil law for things like inheritance and care.
Right, like property rights.
Exactly. It does not cross the threshold into the Penal Code's definition of parricide.
Now, the emphasis on the, quote, legitimate spouse is where things seem to get really, really complicated. Because, human relationships are messy, and the law demands clean paperwork.
Paperwork is everything in this context.
Yeah, and this brings up an incredibly illustrative piece of case law in the notes, People versus Sabonner.
Oh, yes. That is a perfect example of what happens when a rigid national law collides with a diverse cultural reality.
Can you break that down for us?
Sure. So, in this older case, a Muslim man had 3 wives, which was a practice that was entirely permissible under his customary and religious laws.
Right.
And he killed his 3rd wife. Now, originally, the national court held that he was not liable for parricide, but only for standard homicide.
Only homicide, because they didn't recognize the 3rd marriage.
Yeah, exactly.
Like, the law essentially said, hey, we acknowledge this is how your culture operates, but for the actual math of this punishment, she doesn't count as your wife.
That was the exact rationale. Under the strict national civil law at the time, only the first marriage was recognized as creating a, quote, legitimate spouse.
Wow.
So the subsequent marriages, in the eyes of that specific penal code application, they didn't forge the legal bond required to trigger the parricide statute. It was just a massive cultural blind spot.
It really feels like an erasure of their actual lived reality
Yeah.
just to satisfy a technical legal definition.
It absolutely was an erasure, and the notes specifically point out that this ruling had to be adjusted and corrected later.
How did they fix it?
Well, the enactment of the Code of Muslim Personal Laws updated the rule. It formally recognized subsequent marriages by Muslims as legitimate within the national framework, thereby, bringing those spouses under the protective umbrella of parricide.
Oh, good.
Yeah, it's a vital reminder that the law is a living document. It often has to course correct when its strict historical definitions just completely fail to encompass reality.
Which brings us right back to that dark scenario I painted at the very beginning of the deep dive. Let's look at the case of People versus Barang.
A very tragic case.
Yeah. This is a man who lived with his partner for years. They shared a life, but they never actually signed a marriage contract.
Common law spouses?
Right. He kills her. And during the same violent incident, he also kills his illegitimate daughter.
Wait, so if they aren't legally married, does he just get a lesser standard sentence for both of them?
Half right.
Oh.
This is where the mathematical nature of the penal code becomes glaringly obvious.
Okay, lay it on me. The live-in partner, despite the 20 years of shared life and affection, is legally considered a stranger under Article 246 because there is no marriage certificate.
No piece of paper.
No paper. So killing her is categorized as homicide.
But the daughter?
The daughter, even though she is illegitimate, shares a direct vertical bloodline with him.
The blood tie.
Exactly. That blood tie is undeniable. So killing the daughter is parricide.
Wow. So literally in the exact same room, committing the exact same violent act in the same moment, his relationship status splits the crime into 2 entirely different legal universes.
2 different equations.
Yeah. The best and sometimes only proof of that spousal relationship the court will accept is that piece of paper from the civil registry.
It is deeply clinical.
It really is.
And that clinical nature gets even darker and honestly far more complex when we look at the other side of this familial spectrum.
You mean infanticide?
Yes. Under Article 255, we are talking about the killing of a child. But the law doesn't just look at the act, it attaches a highly specific timer to it.
Ah, the 72-hour rule.
Precisely.
Yeah, I read this. To be classified as infanticide, the victim must be a child less than 3 days old.
Yes.
Furthermore, the notes emphasize the child must have been fully developed enough to sustain independent life.
Right. Viability is key.
But get this, if the child is 73 hours old and the parent kills them, it suddenly escalates to parricide.
It does.
But why exactly 72 hours? I mean, it feels like a completely arbitrary line drawn in the sand. Like, what changes in that 1 hour?
I know, it seems completely arbitrary to a modern listener, but it's really not just a random number they pulled out of a hat.
Okay, what's the logic?
Historically, this 72-hour window aligns with several intersecting beliefs from the era when these codes were originally drafted.
Medical beliefs.
Largely, yes. It aligns with old medical beliefs about the viability of independent life and the critical window where neonatal survival was established. But more importantly, it aligns with the medical understanding of the immediate postpartum period.
Oh, like the mother's physical state.
Exactly. The profound physiological and hormonal crash a mother experiences right after giving birth. Historically, this was a window where severe postpartum psychosis was recognized to peak.
Oh, wow. Which leads us directly into one of the most jarring concepts in this entire syllabus.
The mitigating circumstance.
Yeah. There is a special mitigating circumstance attached to infanticide called concealing dishonor.
Yes, this is perhaps one of the most stark examples we have of the law acting as a mirror to historical social values.
It's intense.
If a mother kills her newborn infant to conceal her dishonor meaning, to avoid the public shame and the social destruction of having an illegitimate birth, the penalty is drastically reduced.
Drastically reduced for killing a newborn.
Yes, and this mathematical reduction also applies to the maternal grandparents if they commit the act to conceal their daughter's dishonor.
Go, for those of you listening right now, maybe on your commute, living in an era of social media, public oversharing, and generally, very diverse family structures, the idea of killing a child to prevent neighborhood gossip sounds utterly psychopathic.
It sounds horrifying today.
It prioritizes reputation over human life. It's like the law is acting as this brutal PR firm, basically saying that protecting the family's social standing is a valid mathematical deduction from the crime of murder.
It does. But to understand the mechanism of this law, we have to put ourselves in the shoes of a society where social exile meant something entirely different than it does today.
Okay, paint that picture for me.
We have to look at the Spanish origins of this penal code, specifically the Spanish Penal Code of 1870. The Norts actually cite a prominent Spanish legal commentator, Viada, to explain the rationale.
Right, I saw that. What was Viada's justification for giving a lighter sentence for this? It's so hard to wrap my head around.
Viada argued that the mother in this situation lacks the time and the mental capacity to reflect calmly.
Because she's panicking.
Exactly. She is presumed to be acting under extreme excitement, obfuscation, and sheer blinding panic, driven solely by the terror of her dishonor being made public. It highlights a historical era where social destruction, like becoming a total outcast, ruining the marriage prospects of your entire extended family, total social ruin that was viewed as a fate almost worse than death.
Because there was no social safety net.
Exactly. It meant literal destitution and starvation in many cases. So the law, reflecting the immense weight of that societal pressure, extends a twisted sort of empathy to the mother's panic.
A twisted empathy. It's treated almost like a temporary socially induced insanity.
That's a good way to put it.
But as I read further into the notes, I saw that there was a massive, highly judgmental caveat attached to this empathy.
Ah, yes, the reputation clause.
Right. She has to have a, quote, good reputation to begin with to even get the lighter sentence.
Yes. This is where the law's empathy reveals its underlying class and moral bias. The commentator Albert is cited here.
What does Albert say?
Well, he points out that a prostitute or a woman already known in the community to have a, quote, bad reputation cannot claim this mitigating circumstance.
That is so dark.
The cruel circular logic of the law is that if you have no honor left to conceal, you cannot legally kill to conceal it.
Unbelievable. So a woman who is already marginalized by society, like a woman of ill repute who kills her newborn in exactly the same state of postpartum panic,
yes,
she receives the maximum penalty.
Yes.
But the respectable woman, the one the society values more, receives the lighter one. It is just a stunning look at how morality, class status, and gender expectations are literally codified into prison sentences.
It absolutely is. Now, shifting away from the violence of the family unit, we encounter a section of the code that deals with what the notes call death under exceptional circumstances. This is Article 247.
Okay, what makes it exceptional?
We are moving from a scenario where the law is rigidly protective of the family bond to a scenario where the law actually seems to sympathize with the killer who breaks it.
Oh, this is the classic cinematic crime of passion scenario. So, Article 247 applies when a legally married person surprises their spouse in the act of sexual intercourse with another person and kills one or both of them immediately.
Yes. And it also extends to a parent who surprises their daughter, provided she is under 18 and living in their home in the exact same act.
Right.
And just like parricide, we see that strict requirement of a legal marriage reappearing. The law is explicitly clear here.
Oh, clear.
If you surprise your common law wife, your long-term girlfriend, or your fiancé in bed with someone else and you kill them, this article does not protect you at all.
Because there's no piece of paper.
Right. That would just be standard murder or homicide. Article 247 strictly contemplates a legally married person protecting the sanctity and exclusivity of that specific legal contract.
But what I found truly fascinating, and honestly almost absurdly detailed, is how the law defines the word surprise.
It gets very granular.
Granular is an understatement.
Yeah.
The court is literally parsing human behavior and emotional reactions into fractions of a second. What legally counts as a surprise here?
The Supreme Court defined it broadly as coming upon them suddenly and unexpectedly.
Seems straightforward.
But the real-world applications of this definition are where the jurisprudence gets incredibly specific. For instance, the notes provide the case of People versus Gabriel.
Oh, the keyhole case.
Yes. In this case, the husband didn't just burst through the front door and react instantly. He actually peeped through a hole in the kitchen door for quite a while.
He just stood there.
He stood there. He watched the preparatory acts, waited for the actual commencement of sexual intercourse, and only then did he break in and attack.
And the court said, wait, that still counts as a surprise, even if he stood there watching, waiting, and calculating his entry.
Interestingly, yes.
How does that make any sense?
The court ruled it was still by surprise because the discovery itself was the initial shock, even if he waited to confirm the act.
Okay.
But you must contrast that with the strict requirement of being, quote, in the act. The law demands actual sexual intercourse. The notes reference another case, People versus Gonzalez, where the husband surprised the wife after the act had concluded.
Oh, wait.
She was rising up from the bed and the man was buttoning his trousers.
And the strict interpretation says that is excluded because they were done.
Exactly. The court held that since the act was finished, the absolute peak of the passion should have theoretically begun to subside.
This hair splitting.
It is. Furthermore, mutual acts of lasciviousness, intense foreplay, or just sleeping in the same bed, as seen in the case of People versus Bakunin, are entirely excluded.
Wait, just sleeping in the same bed doesn't count?
No. You must catch them in the literal act of physical coition, or immediately thereafter as a direct, continuous pursuit.
Wow.
Let me give you another scenario. If a husband comes home, finds a man jumping out the bedroom window, and his wife is begging for pardon on the floor, but he didn't actually witness the physical act itself.
Yeah.
If he kills her then, he cannot claim Article 24(7).
Really?
Really? That is parricide.
That is just wild. So if a person manages to thread this incredible legal needle like, you are legally married, you catch them in the literal physical act, you don't wait too long, you kill them in a blind rage. What does this all mean for the penalty? Do you just go to prison for, I don't know, less time?
Here is the massive twist in the syllabus. The penalty isn't prison at all.
Wait, what?
The penalty is destierro.
Which means banishment, right?
Yes. You are forbidden from entering a specific geographic radius, usually 25 to 250 kilometers around a certain place, usually the victim's residence, for a set period of years.
That's it. Just stay out of town.
That's it. But what's crucial to understand, as the landmark case of People versus Arakel established, destierro in the context of Article 247 is not actually a punishment.
Okay, hold on.
Article 247 does not define and penalize a felony.
Wait. If you killed two people and the state banishes you, how is that not a punishment? What is it?
It is classified as a protective measure.
Protective.
The law justifies the outburst of passion. It says, essentially, any reasonable person would completely lose their mind in this exact fraction of a second.
Okay.
The banishment is intended to remove the killer from the immediate vicinity, not to punish them, but to protect them from blood feud reprisals from the dead spouse's family or the lover's family. The state acts almost as a referee.
That is wild. The state is acting like a referee, sending a hockey player to the penalty box, not to punish them for the fight, but to keep the rest of the opposing team from jumping them on the ice.
That is an excellent analogy. That's a perfect way to conceptualize it. The state recognizes the volatility of the situation and literally forces physical distance to allow tempers to cool across entire extended families.
Wow. Okay. We've talked extensively about what happens when malicious intent successfully extinguishes a life within a family or marriage. Let's look at what happens when violence loses its target entirely and becomes like a force of nature.
Yes.
I want to dive into the tumultuous affray, covered in Articles 251 and 252.
A tumultuous affray is, at its core, a chaotic brawl. But the legal requisites are very specific.
Okay, what are they?
First, there must be at least 4 people involved.
So a 3-person fight is just a fight.
Right. Second, and most importantly, They cannot be organized groups fighting for a common purpose.
Got it.
It cannot be two rival gangs having a pre-planned rumble where everyone assaulting each other indiscriminately.
So a heated argument at a crowded bar that suddenly spills into the street and turns into a 20-person riot where literally no one knows who started what.
Exactly. And the crux of Article 251 is this specific scenario. In the course of this massive, confusing chaos, someone is killed.
Okay.
But because of the sheer confusion, the darkness, or just the sheer number of blows flying around, it cannot be ascertained who actually delivered the fatal strike.
Okay, my analogy for this,
Yeah.
it's like playing a terrible high-stakes game of Clue.
Let's hear it.
We know the weapon was a broken bottle, right? And we know the room was the alleyway. But we absolutely cannot figure out the killer.
Right. Now, normally, under the idea of innocent until proven guilty, if you can't prove who dealt the fatal blow, you'd think everyone walks away free because of reasonable doubt.
You would think that, yes.
But instead, the law just hands out penalties to anyone who is throwing punches.
That is highly accurate.
Seriously.
Yes. If the person who inflicted the fatal wound is eventually identified, then the tumultuous affray rule drops, and it's just a standard charge of homicide against that specific individual.
Right, because you found the killer.
Exactly. Article 251 only activates when the killer remains a ghost in the crowd. When that happens, the law punishes the person or persons who inflicted serious physical injuries on the deceased during the brawl.
And if they don't know who did that?
If even they can't be identified, then all persons who used any violence upon the victim's body are punished. Man, it feels like a massive compromise. You might have just, punched the guy in the shoulder, someone else stabs him in the back, but because nobody saw the knife, you are going down for contributing to his death.
It is a compromise, but it is rooted in a deep legal philosophy regarding the corpus delicti.
The body of the crime.
Yes, the body of the crime. The law absolutely abhors a vacuum of accountability.
Oh, I see.
A human life was taken unlawfully. The dead body is proof of that. If the collective chaos caused the death, the law forces the collective participants to share the burden of that outcome.
That makes a dark kind of sense.
It is a necessary safeguard. Think about it. It prevents a terrifying scenario where a mob could just murder someone in broad daylight and all escape justice simply by creating enough mutual confusion to hide the killer.
Wow. Yeah, if you could just get out of it by making it messy, everyone would do that.
Exactly.
Let's shift our focus a bit. We've looked at the family, we've looked at crimes of passion, and we've looked at chaotic brawls. Now we need to examine deliberate, calculated violence outside the home.
The distinction between murder and homicide.
Right. I think a lot of people, use those terms interchangeably in everyday conversation, like they are just synonyms for killing.
They do, but in the strict architecture of the Penal Code, the distinction is profound.
How so?
It is the difference between a standard human tragedy and the ultimate manifestation of malice. Homicide, under Article 249, is the baseline.
Baseline killing.
It is the unlawful killing of a person without any special qualifying circumstances. It implies intent to kill, but without the specific aggravating factors that show profound depravity.
So what exactly elevates that baseline homicide to murder under Article 248?
It requires the presence of specific, quote, qualifying circumstances at the time of the killing. These are elements that show a deeper level of capulation, unfairness, or cruelty.
Give me an example.
The most common and arguably the most important one is treachery.
Treachery. It sounds like a word you'd hear in a Shakespeare play, right?
Yeah.
Or a medieval courtroom. What does it mean in modern jurisprudence?
Treachery, or alevosía in Spanish, means the attacker consciously adopted a method of attack that ensured zero risk to themselves.
Zero risk.
It is the legal definition of a coward's kill. It means stripping the victim of any chance to defend themselves or retaliate.
Okay.
For example, the syllabus cites the case of People versus Catapon. In this case, the victim was shot suddenly and without warning while his hands were raised in the air in a gesture of surrender or peace.
Oh, man.
He had no weapon, no posture of defense, no way to strike back. The attacker took absolutely no risk. That conscious choice to attack a defenseless target is treachery, and it immediately elevates the crime to murder.
Another qualifying circumstance mentioned here is evident premeditation.
Yes.
And the law is very specific here. It isn't just I thought about it a few minutes before I did it. The law actually puts a stopwatch on human intent.
It really does. For evident premeditation to qualify a killing as murder, the prosecution must prove 3 distinct things.
What are they?
First, the exact time the offender decided to commit the crime. Second, an overt act showing they clung to that dark determination. And crucially, third, a sufficient lapse of time between the decision and the execution of the act.
And the syllabus notes this lapse of time must be at least 3 hours.
Yes.
Why 3 hours? Why not 1 hour or 24?
The 3-hour rule is a fascinating benchmark for the human conscience. The law operates on the assumption that 3 hours is enough time for a normal human being's blood to cool down.
The adrenaline fades.
Exactly.
Yeah.
It's enough time for the adrenaline to fade, for the conscience to intervene, for a reason to return, and for the person to reflect and say, what am I doing? I shouldn't do this.
Right.
If 3 full hours pass and you still pick up the weapon, the law says this wasn't a sudden, uncontrollable impulse. This was a cold, calculated, deeply rooted decision to extinguish a life. The malice is cemented.
That is chilling when you frame it as a grace period for the conscience that the killer just completely ignored.
It is.
And then, reading further down this list, there are qualifying circumstances that go beyond cold calculation and enter the realm of pure macabre. Subparagraph 6 talks about cruelty and outraging or scoffing at his person or corpse.
Yes. These are the cases that make headlines for their absolute depravity.
I can imagine.
The syllabus cites a notorious, horrifying case, People versus Carmina. In this instance, the killer didn't just end the victim's life, he dismembered the corpse, severing the head and limbs.
Oh, God.
But the law goes further to highlight the scoffing, which implies a show of deep, grotesque irreverence for human remains.
The details in the notes here are honestly hard to read.
They are deeply disturbing. The killer opened the body cavity, removed the intestines, and literally hung them around the neck of the victim's own brother like a necklace.
That is, I have no words.
He then facetiously described the victim's lungs and liver as pulutan, which is the local term for drinking snacks.
It goes beyond taking a life. It's pure sadism.
Yes. And the legal rationale for making this a qualifying circumstance for murder is that a mind capable of outraging a corpse to that degree, a mind that finds humor in desecration, is fundamentally a much greater threat to the fabric of society than someone who kills in a standard brawl.
Absolutely.
It requires the absolute maximum penalty the state can levy.
Okay, let's look at the means of killing, because the syllabus mentions murder by means of fire or poison. And this brings us to an incredibly important and sometimes frustrating legal concept: intent.
Intent. Intent is the central pillar of criminal law.
Walk us through it.
Let's look at murder by means of fire through the lens of the cited case, U.S. versus Burns. If someone intentionally sets a house on fire with the specific goal of burning the person sleeping inside to death, that is unequivocally murder by fire.
That makes perfect sense. Fire is the chosen weapon.
But the facts in the Burns case were different.
How so?
The accused set fire to a car located in the basement of a house. The fire unexpectedly spread rapidly, the entire house burned down, and a person inside died. The court ruled this was homicide, not murder.
Wait, because he didn't intend for the fire to kill the person, he just wanted to burn the car?
Precisely. To be murder by fire, there must be an actual subjective design to kill a human being and a purposeful adoption of fire as the means to execute that design.
I see.
The fire in the Burns case was the instrument of a tragic accident stemming from arson, not the intended weapon of a murder.
Okay, I understand the fire example. The fire was the tool, not the target. But let's look at the poison case mentioned here, the Spanish fly case, People versus Galura.
Yes, a very controversial case.
Very. The notes detail that a man gave a woman cantharide, which is Spanish fly, not to kill her, but just to excite her sexually.
Right.
But he miscalculated the dosage, the substance was highly toxic, and she died a painful death. And the court said this is homicide, not murder by poison, because he didn't have the explicit intent to kill.
That is the correct application of the prevailing doctrine, yes.
I have to push back on this.
Go ahead.
Because to anyone listening, this sounds like a massive legal loophole for reckless predatory behavior.
I completely understand why you'd say that.
If you willingly, secretly administer a highly toxic substance to someone without their consent, shouldn't the law presume you accept the risk of their death?
It's a strong argument.
Like, if I hand you a glass of battery acid just to see what it does to your vocal cords, I shouldn't be able to stand in court and say, oh, Your Honor, I didn't mean to kill him. I just wanted to ruin his voice.
Your frustration is completely justified, and it actually echoes a major debate within the legal system itself.
Really?
Oh, yes. In fact, in that very case, People versus Galora, 2 Supreme Court justices wrote a passionate dissent.
What do they say?
Those dissenting justices argued exactly what you were arguing, that the use of poison is so inherently treacherous, so stealthy and dangerous, that deploying it should automatically qualify the resulting death as murder, regardless of what the perpetrator claims their subjective intent was.
Because the act of poisoning someone secretly shows a fundamental disregard for their life, regardless of the end goal.
Exactly. But we have to look at why the majority opinion overruled them and why it stands as the rule today.
Okay, what?
It goes back to the absolute core philosophy of criminal liability. The distinction between dolus, which is deceit or deliberate malicious intent, and culpa, which is fault or negligence.
Dolus and culpa.
Right. Criminal law is obsessed with the subjective mind of the accused at the exact moment of the act. Think of intent as a filter.
A filter for what?
It is the filter the law uses to separate a tragic accident from a monster. Without that filter, every fatal car crash caused by a speeding driver would be prosecuted as murder.
Oh, I see.
The law insists that we cannot punish a person for a specific subjective intent to kill that they did not actually possess, even if their actions were wildly irresponsible, predatory, and resulted in a horrific death.
So it's about the state of mind.
Yes. So it bridges the gap. It punishes the act as intentional homicide due to the recklessness, but it denies the maximum penalty of murder because the specific malice aforethought wasn't there.
A very fine, very technical line between justice and what honestly feels like a technicality.
It is the tightrope the legal system walks every day.
Okay. We've talked extensively about what happens when malicious intent successfully extinguishes a life. But what happens when that intent falls short?
When the victim survives.
Right, when the victim survives but is forever changed. This is where we move into the realm of physical injuries. And looking at these notes, the law suddenly shifts from being a moral arbiter to acting like a bizarre, highly specific medical ledger.
It does. It calculates the exact value of human body parts.
Literally putting a price tag on anatomy.
It places a literal mathematical hierarchy on the human anatomy. At the very top of this grim ledger is mutilation, covered under Article 262. And there are 2 distinct types.
The worst type, carrying the heaviest penalty, is castration.
Yes, intentionally depriving someone, totally or partially, of an essential organ for reproduction.
Why is that the highest?
The law views the capacity to procreate, the ability to pass on life, as so fundamental to human existence and societal continuation that deliberately destroying it is treated as a crime almost on par with taking a life itself.
That makes sense. And the second type?
The second type of mutilation is mayhem lopping or clipping off other body parts, like severing an ear or cutting off a nose, with the deliberate intent to deprive the victim of that specific part.
But if it's not a deliberate surgical mutilation, if you just get into a fight and beat someone up really badly, we enter Article 263, serious physical injuries.
Right.
And this is categorized meticulously by recovery time and permanent damage. There's a 30-day medical bracket, a 90-day bracket. But the part that absolutely fascinated me is the deformity rule.
Ah, yes. This is where the law is forced to become an aesthetic judge.
An aesthetic judge.
Yes. A serious physical injury includes an injury that leaves the victim, quote, deformed. The legal definition of a deformity is a physical ugliness that is conspicuous, permanent, and creates a definite abnormality in the person's appearance.
Conspicuous and visible. So the notes point out that a massive jagged scar on your abdomen, which is usually covered by clothes, is not considered a legal deformity.
Generally, no.
But a smaller scar on the upper part of the neck or the face is.
Because it is visible to the world.
Right. And then there's the jurisprudence around teeth, which is oddly specific.
You are referring to the People versus Balabar case.
Yes.
The Supreme Court ruled that the loss of a front tooth and incisor impairs a person's appearance and constitutes a disfigurement that nature cannot repair. Therefore, punching someone and knocking out their front tooth elevates the crime to a serious physical injury resulting in deformity, carrying a heavier prison sentence.
But if you knock out a molar in the back of their mouth,
it's not a deformity because it isn't conspicuous and visible when they speak or smile.
It's like the penal code is moonlighting as a cosmetic dentist. We will send you to prison for 5 years if you hit the incisor, but the bicuspid will only cost you a few months.
It is remarkably specific.
It feels almost comical how specific it is, like the case of U.S. versus Solis, where the loss of just the outer portion of the earlobe was solemnly ruled a permanent deformity.
It sounds absurd when we talk about teeth and earlobes, but it is meticulous for a profound reason.
And what's that?
The law has to quantify human suffering to assign a proportional penalty. Losing a front tooth changes how the world perceives you. It changes how you smile, how you speak your confidence.
That's true.
It is a permanent social and physical alteration. The law is trying to mathematically balance the scales for that exact theft of normalcy.
Okay, I can see that. Now let's transition to a very strange, almost archaic corner of this syllabus. Duels, under Article 260.
Oh, the dueling laws.
Yeah, we are talking about formal combat with seconds, measuring weapons, the whole Alexander Hamilton Aaron Burr scenario.
Right.
The law says that even if both parties explicitly, in writing, agreed to fight to the death, if you injure your opponent, you go to jail for those injuries.
You do.
My question is, why does the law care if both adult parties fully consented to the violence? Like if we both say, let's do this, why does the state step in?
Because of a fundamental principle of statehood, the state holds an absolute monopoly on violence.
Okay, unpack that. Why does the state own the violence?
Because you, as an individual citizen, do not own your life or your physical body in a way that allows you to legally contract them away for destruction.
Oh, wow.
You cannot legally consent to be murdered, and you cannot legally consent to be maimed. The state has an overarching supreme interest in preserving the lives, the bodily integrity, and the productivity of its citizens.
Because they need you alive and working.
Exactly. This state interest entirely overrides any private gentleman's agreement to duel. This is also why merely challenging someone to a formal duel is a separate crime under Article 261, even if the duel never actually takes place.
Just sending the challenge is a crime.
Yes. The challenge itself is viewed as an affront to public order and the state's authority.
This connects directly to the modern laws on hazing.
Right.
Republic Acts 8149 and the newer 11053.
Exactly. Hazing is a modern, insidious incarnation of this illegal consent to violence.
It's because the pledges agree to it.
Right. Fraternities and organizations use physical or psychological violence as an initiation rite, operating under the false premise that the pledges, quote, consented to be beaten.
Right.
The law is draconian here to break that illusion. If death, rape, sodomy, or mutilation results from a hazing ritual, the penalty is reclusion perpetua and a massive financial fine.
And the Anti-Hazing Act of 2018 made it even stricter. The notes say that mere presence at a hazing event creates a prima facie presumption of participation. Could you define prima facie for us?
Prima facie is a Latin term meaning on its face or at first glance. In legal terms, a prima facie presumption means that the evidence is sufficient to prove a fact unless it is disproved or rebutted by the defense.
That is a massive legal shift in how we handle guilt. Usually the prosecution has to prove beyond a reasonable doubt that you actually threw a punch or swung a paddle.
It is a radical shift born of necessity.
Necessity.
With hazing, the culture of silence, the, quote, omerta of the fraternity, is so strong that prosecutors could almost never prove who landed the fatal blow. Nobody talks.
Oh, right, the brotherhood.
Exactly. So the law adapted. It says, if you are in the room while the violence is happening, if you are part of the crowd, we legally presume you are a participant in the crime until you can definitively prove otherwise.
Wow. Guilty until proven innocent, basically, for just being there.
It targets the collective complicity, the cheering, the watching, the silent approval that allows hazing to survive in the first place.
Okay. We've covered violence in the family, in mobs, calculated murder, and consensual brawls among healthy adults. Now let's explore how the law handles life at its absolute margins.
The unborn and those wishing to end their lives.
Yes. Let's look at abortion first, Article 256.
The Penal Code distinguishes between intentional and unintentional abortion.
Okay.
Intentional abortion can be committed with or without the pregnant woman's consent, but unintentional abortion is a very specific, strictly construed legal construct. It must involve physical violence.
Right. The notes give a fascinating, almost unbelievable example from an old Spanish Supreme Court decision.
It's a fright case.
Yes. A man points a gun at a pregnant woman. He threatens her. She is so profoundly frightened by the gun, the stress causes her to suffer a miscarriage.
And legally, under this specific code, that is not unintentional abortion.
That is insane to me. What is it?
It is merely prosecuted as the lesser crime of threats, because there was no actual physical violence exerted on her body. The law defines violence in this context as actual physical kinetic force.
Okay.
If the abortion is a result of fright or emotional distress, or even a scenario where a husband gives his wife a bitter medicine to cure a stomachache and the toxicity accidentally causes a miscarriage, none of that qualifies as unintentional abortion.
But if he strikes her with a bottle, like in the cited case of U.S. versus Jeffrey, and she miscarries as a result of the blow, even if he didn't know she was pregnant at the time, that is unintentional abortion.
Correct. The physical strike is the violence. The miscarriage attaches the heavier penalty to the initial physical assault.
And what about the medical professionals involved in intentional abortions? The syllabus seems to carve them out specifically.
It does. The law reserves the absolute maximum penalty for physicians, midwives, and pharmacists who cause or assist in an abortion. Article 259 explicitly targets them.
Why are they punished so much more harshly than just a regular person causing an abortion?
Because of a perceived profound betrayal of their calling.
Like breaking the Hippocratic Oath.
Essentially, yes. The commentator Albert explains that there is a, quote, heavier guilt in making use of scientific medical knowledge for the destruction of human life when that knowledge was entrusted to them by society solely for life's preservation.
They're twisting their skills.
Exactly. They are twisting their life-saving skills into tools of destruction, and the law punishes that hypocrisy and breach of trust severely.
Okay, let's look at the other margin of life, the end. Giving assistance to suicide, Article 253.
This article punishes two different acts.
Which are?
The first is assisting another to commit suicide by furnishing the means, giving them the poison, lending them the gun, providing the rope. The second, more severe act is lending assistance to the extent of actually doing the killing yourself, like you pull the trigger for them.
The penalty for actually doing the killing is reclusion temporal, which is essentially the exact same penalty for standard homicide.
Yes, because practically and legally speaking, you committed a homicide. The victim's consent to be killed, as we discussed with duels, is legally void.
But here is the note in the syllabus that really struck me, and I think it will strike anyone listening. It explicitly says, person attempting to commit suicide incurs no criminal liability.
Yes.
And then the commentator Reyes adds a philosophical note. They are, quote, more deserving of pity than penalty.
It is a remarkable, quiet moment of humanity in an otherwise incredibly rigid mathematical code.
It really is. To me, it feels like a rare moment where the blindfold of justice slips just a fraction, and the law looks down at the human condition and actually shows deep compassion.
It's a poignant shift.
Because the rest of this syllabus is a strict equation of penalties, calculating the exact millimeter of a lost front tooth. But here, the law pauses and says, we aren't going to punish you for your despair.
It connects back to the core philosophy of why we criminalize behavior in the first place.
How so?
The primary aim of criminal law is to punish malicious intent directed against others, and to protect society from dangerous actors. It recognizes that a person in the depths of suicidal ideation is not a malicious actor attacking the social order. They are a victim of their own profound mental anguish.
Right.
Punishing them serves no rehabilitative purpose for them, and it provides no protective benefit to society at large. It would be cruelty for the sake of cruelty. So, the law steps back.
Which brings us to our final section, and honestly, perhaps the most complex. The evolution of bodily autonomy.
We are talking about rape.
Yes, and looking at these notes, specifically the major amendments from Republic Act 83533 and Republic Act 11648, this is where you can clearly see the law desperately trying to modernize.
Shedding its archaic skin.
Exactly, trying to catch up with our evolving understanding of consent, power dynamics, and human rights.
Historically, the legal definition of rape was incredibly narrow and heavily burdened by archaic notions of female chastity and male property.
Male property.
Yes. For decades, it was categorized in the Penal Code under crimes against chastity. The fact that it is now listed under crimes against persons is a monumental philosophical shift.
It acknowledges the actual crime.
Right. It acknowledges that rape is not a theft of a woman's virtue or a father's property, but a violent, fundamental assault on a person's bodily autonomy.
Let's unpack the two modes of rape now defined by the modern law.
Okay. The first mode is the traditional definition. A man having carnal knowledge of a woman through force, threat, or intimidation.
And the second mode.
The second mode, introduced by these newer laws, expands the definition massively to reflect reality. It recognizes that sexual assault takes many forms. It includes the insertion of objects or instruments into genital or anal orifices, or the insertion of the penis into the mouth.
Okay.
And crucially, it specifies that this second mode can be committed by, quote, any person against any person.
So it legally recognizes male victims and female perpetrators in a way the old law simply ignored.
Exactly. It removes the gendered blinders that existed for over a century.
Let's talk about the force required. Because reading the older cases cited here, they always talk about the woman having to fight back essentially to the death.
That was the punishing doctrine of, quote, manifest and tenacious resistance.
Manifest and tenacious resistance.
Yes. Cases like People versus Lago required the victim to demonstrate a physical struggle that taxed their physical powers to the absolute utmost limit.
That's horrible.
It was. But the law has evolved to recognize that force doesn't have to be a bloody physical brawl. Force can be psychological intimidation.
Moral ascendancy.
Yes. The law now recognizes that a father abusing his daughter, a teacher abusing a student, or an employer abusing an employee doesn't necessarily need to use physical force.
Because the power dynamic is the force.
Exactly. The immense moral, psychological, and economic weight of their authority is enough to crush resistance. That power dynamic substitutes for physical violence.
Makes total sense.
Furthermore, the law recognizes rape when the victim is, quote, deprived of reason or unconscious. If someone is asleep or given a drug or has a severe mental disability, they simply cannot consent.
And then there is statutory rape, which deals with age.
Yes. Sexual relations with anyone under 16 years of age is statutory rape, regardless of whether they supposedly consented. The law deems them biologically and psychologically incapable of providing legal consent.
But there is a very specific, complicated exception in the new RA 1:6 and 48 law, the, quote, Romeo and Juliet clause.
Right. If the victim is under 16, but the age difference between the parties is not more than 3 years, and the act is proven to be consensual, non-abusive, and non-exploitative, there is no criminal liability.
But there's a hard floor to that, right?
Yes. This exception completely vanishes, acting as an absolute hard line if the victim is under 13.
It's the law trying to navigate the messy reality of teenage relationships versus actual predatory behavior. But speaking of messy, horrifying realities, we have to talk about marital rape.
Because historically, this concept didn't exist in the law.
Which is mind-boggling.
Under classical legal theory, marriage was viewed as an irrevocable, permanent contract of consent.
Meaning?
The archaic view is that a wife legally gave up her body to her husband on their wedding day, and she could not legally retract that consent for the duration of the marriage.
That is just horrifying.
It is. But modern law, through these amendments, finally recognizes that a husband can rape his wife. A marriage certificate is not a license for sexual violence.
Good.
However, this brings us to what is easily one of the most controversial, baffling, and complex provisions in the entire syllabus. Article 266C.
The forgiveness clause.
Yes.
I read this 3 times because I couldn't believe my eyes. It says that a valid subsequent marriage between an offender and the offended party extinguishes the criminal liability.
Yes.
And if they're already married, formal forgiveness by the wife extinguishes the criminal action.
That is exactly what the law currently states.
I have to push back here, and hard. This feels like a massive, glaring contradiction.
It certainly feels that way.
We just spent this entire section establishing that rape is the ultimate violation of bodily autonomy, that it's a heinous crime against a person, moving it away from the old property laws.
Right.
But then the law turns around and says, actually, a wedding ring acts as a retroactive get-out-of-jail-free card. It essentially incentivizes a rapist to coerce, threaten, or bribe their victim into marriage just to escape a prison sentence.
Your outrage is exactly the reaction many modern legal scholars and human rights advocates have.
It just makes no sense.
How do you synthesize this immense tension? You have to understand that this clause shows a legal system caught in a profound, ugly transition.
A transition between what?
Between archaic traditional views of social order and modern views of human rights.
Unpack that for me.
Historically, if a woman was raped, society deemed her ruined. Her prospects for marriage and social standing were destroyed.
Right.
The traditional, albeit patriarchal and deeply flawed legal, quote, cure for this social ruin was to force the rapist to marry the victim.
To save her reputation.
Exactly, thereby, quote, restoring her honor in the eyes of the community and providing for her financially.
So the law is holding on to this outdated Victorian idea of marriage as a restorative cure for sexual violence.
Yes. The forgiveness clause is a ghost of that old worldview lingering in a modernizing penal code. It conflicts directly with the modern human rights-based view that absolute bodily autonomy is paramount and cannot be traded away or cured by a civil contract.
It's a total clash of eras.
It is the perfect example of how legal systems are not perfectly logical, pristine machines. They are messy, evolving records of human civilization, carrying the heavy baggage of the past, even as they try to step into the future.
We also have to mention the Rape Shield Law, RA 8505, before we close, because this radically changes how these cases are actually fought in a courtroom.
It's a vital protection.
How did it used to work?
Historically, defense attorneys would put the victim on trial. They would dig into the victim's past sexual conduct, their reputation, their clothing, trying to prove they were unchaste and therefore must have consented.
Victim blaming.
Blatant victim blaming. The Rape Shield Law disallows this evidence. It essentially says that a person's sexual history is entirely irrelevant to the question of whether they were raped on a specific occasion by a specific person.
That is so important.
It is designed to protect victims from being re-traumatized by the brutal machinery of the legal process.
Which is a huge step forward in recognizing the humanity of the victim within that machinery.
Absolutely.
Okay, we have covered a massive amount of ground today. We've looked deeply at Title VIII of the Philippine Criminal Law Syllabus. And what strikes me is that this isn't just a list of crimes. It is a fascinating and sometimes terrifying map of human vulnerability.
It really is a detailed map of all the ways we can break each other, physically and socially.
Yes, from calculating the exact definition of a deformity, measuring the millimeters of a lost front tooth to balance the scales of normalcy, to navigating the tragic, violent complexities of the tumultuous affray where the killer is lost in a crowd, but the law demands accountability anyway.
The law demands an answer.
Exactly. The law tries to bring a mathematical order to our darkest, most chaotic moments. It tries to be that X-ray machine we talked about at the beginning.
Yeah.
It tries to find the jagged white line in the messy reality of human behavior.
But as we've seen today, the X-ray isn't always clear.
No, it's not.
Sometimes the law has to squint and adapt. It has to measure intent. It has to define the rigid boundaries of family. And sometimes it carries the dark shadows of the past with it as it tries to move forward.
It really does. And I want to leave you, the listener, with a final provocative thought to mull over as we finish this deep dive.
I think this is a great point to ponder.
Throughout this entire deep dive, every single crime we discussed against a person required a physical act in the real world.
Right.
A strike, a weapon, a poison, a physical insertion. But as we move into a future dominated by deep fakes that can ruin a reputation in seconds, extreme cyberbullying that drives people to despair, and sophisticated psychological manipulation, we have to ask, how will the definition of crimes against persons have to evolve?
That is the big question.
What happens to the penal code when the most devastating, life-altering violence leaves absolutely no physical mark on the body?
That is the frontier the law will have to face next, and it will challenge everything we've discussed today.
Thank you for taking this profound, heavy journey into the syllabus with us today. It's a reminder to keep questioning the rules that govern us, because those rules tell us exactly who we are as a society. Keep diving deep.
Welcome to the debate. Imagine a scenario where a person commits, the most heinous act imaginable, murdering their spouse. Normally, under the law we're examining today, they would face life in prison.
Right. The absolute maximum penalty.
Exactly. But if they commit that exact same act just 10 seconds earlier, under the exact right circumstances, they don't spend a single day in a jail cell.
It's a massive shift.
It really is. Today, we're drawing from the Target 8 syllabus in Criminal Law 2 to look at a space where the law attempts to measure the exact moment a human mind snaps.
Specifically, we're looking at Article 247 of the Revised Penal Code. This deals with what the law calls exceptional circumstances.
Which is a very clinical term for something so visceral.
Yeah, it really is. It basically applies when a legally married person surprises their spouse, in the act of sexual intercourse with another person. And then, in that blinding moment of discovery, they kill one or both of them, or inflict serious physical injury.
And this is really where the penalty structure becomes fascinating. Under Article 246, the baseline rule is that killing a spouse is parricide, which is one of the most severe crimes on the books.
Oh, absolutely.
But under Article 247, if the strict requisites are met, the penalty drops down to something called destiro, which is essentially banishment.
Right, and our central disagreement today rests on how courts should interpret the trigger for that extraordinary exception. I take the position that the law must recognize psychological reality over clinical definitions.
Meaning, you think the preparatory acts are enough?
Yes. Demanding proof of literal physical penetration ignores the very human reality that preparatory sexual acts trigger the exact same blind impulse of rage that the law intends to accommodate.
And I represent the opposing view. To prevent premeditated murder from being disguised as a crime of passion, courts must strictly and literally demand proof of physical coercion. The law has to draw a hard, objective line regardless of how messy human emotions might be.
Well, I come at it from a different way. The law is not a clinical laboratory, right? It deals with raw human emotion.
I see why you think that. But let me give you a different perspective. We have to start by understanding just how massive a shift Article 247 represents. It is what we call an absolutory cause.
Right.
If you're listening to this, you might be wondering how anyone gets a free pass from murder just because they were cheated on. They don't. Think of an absolutory cause as a legal eraser. You committed the physical act of killing, but the law decides to wipe away the standard penalty because the circumstances are so extraordinary.
It fundamentally changes the nature of the crime.
Exactly. The court doesn't even penalize a felony in the normal sense. It substitutes discharge for the severe penalties of parricide. And here is a crucial insight. Discharge is not actually a punishment.
Wait, really? It's not a punishment?
No, it's a protective measure. The state mandates that the killer be banished from a certain radius, usually 25 to 250 kilometers, to protect them from reprisals by the deceased angry relatives.
Ah, so the state is stepping in to prevent a blood feud.
Benefit, literally wiping away a murder charge to protect the killer. The requisite of surprising them in the act must be objectively and narrowly construed. It has to be strictly tied to the carnal act itself.
But if we broaden this to include preparatory acts, we create a dangerous, subjective gray area. We could accidentally allow abusers to justify murder based on mere suspicion or, just a compromised situation.
I come at it from a different way. The entire justification for Article 247 is that the accused is acting in a justified burst of passion. That is the philosophical heartbeat of this law.
But how do you measure that passion?
By looking at the reality of it. We're trying to regulate a moment of profound, catastrophic psychological trauma. I rely heavily on the rationale championed by Justice Laurel in his famous dissent on this issue.
Ah, yes, the Laurel dissent.
Yes. It is entirely irrational to require an offended spouse to stand by and watch mutual acts of lasciviousness. You're essentially forcing them to act as a voyeur to their own ultimate betrayal, waiting for physical coercion to take place before their rage is legally recognized.
I mean, I understand the emotional weight of that.
It's just absurd. To demand this clinical patience from someone experiencing a blind impulse does violence to the reason and purpose of the law. You cannot mandate rational, stopwatch patience in a profoundly irrational moment.
But if we don't use a stopwatch, or rather a strict definition of the act, what are we measuring? Let's look at the baseline definition established in the landmark case People versus Gonzalez.
I knew we'd get to Gonzalez.
We have to. The majority ruling there is explicit. It states that sexual intercourse is limited to the carnal act itself. It explicitly excludes mutual acts of the character of lasciviousness that are merely a prelude.
Which is incredibly rigid.
But necessary. Think of this law like a circuit breaker. It is designed to trip only under an exact catastrophic surge of current, actual physical coercion. If we allow the breaker to trip during the prelude, we are legally validating paranoia.
Paranoia? How is catching your spouse undressing with someone else paranoia?
Because where does the prelude begin? A kiss? An embrace? Taking off a shirt? The moment we move away from the objective reality of the carnal act, we are guessing at the mental state of the accused. The circuit breaker must have a hard, unyielding threshold.
I'm sorry, but I just don't buy that. Let me tell you why. That circuit breaker analogy completely ignores how the human brain actually processes trauma.
How so?
You're treating human passion like a light switch that only flips when the bedroom door opens on a specific anatomical configuration. But psychology shows us that this kind of rage is a flash flood. Watching the preparatory acts, seeing your spouse undress with someone else, that is the dam breaking.
I'm not denying the rage exists.
But you're denying its legal relevance. You cannot tell a victim to wait until they are fully underwater before the law recognizes they are drowning. And the absurdity of your circuit breaker is perfectly illustrated by the very facts of the Gonzalez case you just cited.
The facts in Gonzalez are definitely challenging. I will concede that.
Challenging is an understatement. In Gonzalez, the accused surprised his wife essentially seconds after the act. She was already rising up, and the man was frantically buttoning his drawers.
Right. They were caught after the fact.
Exactly. Yet, the majority excluded the husband from the benefit of Article 247 because, well, he didn't witness the literal, active, physical penetration. That is a massive failure of jurisprudence to map onto reality. Everyone in that courtroom knew what had just happened.
I understand why that feels wrong.
It's why Justice Moran's concurring opinion in Gonzalez is so vital. He points out that it should be enough that the circumstances reasonably show that the cardinal act is being committed or has just been committed.
But reasonably show is a slippery slope.
Buttoning drawers and rising from a bed is a circumstance that screams the act has occurred. The justified burst of passion doesn't care about the exact anatomical positioning of the offending parties at the exact millisecond the doors opened.
I will admit, on a purely human level, sending a man to prison because he arrived 5 seconds too late feels morally grating. It feels terribly unfair.
Because it is unfair.
But legally, look at what happens when you loosen the requirement of visual confirmation. The law absolutely demands the surprise element to be tied to visual confirmation of the act, to separate traumatized rage from calculated execution based on suspicion.
But suspicion and surprise are two different things.
Exactly. And the courts have drawn a hard line between them. Consider the story in People versus Buchanan. In that case, a husband finds his spouse simply sleeping in the same bed with another person.
Right, a highly compromised situation.
It's highly suspicious. It's a massive betrayal of trust. But the court excluded it from Article 247. Why? Because discovering your spouse sleeping next to someone doesn't trigger the visceral, blinding trauma of witnessing them actively engaged in intercourse.
Sure, but sleeping is a static state.
Okay, well, consider People versus Marquez. A husband arrives home, sees a man jump out of the window, and his wife is on the floor begging for a pardon. He kills her. The court ruled that was parricide.
Because he didn't actually see the act?
Exactly. He assumed the sexual act happened, and he was almost certainly right. But the law requires you to actually surprise them in the act. Without that rigid objective requirement, you are allowing someone to execute their spouse based on circumstantial evidence. We cannot allow circumstantial evidence to be an absolutory cause for murder.
But you're pointing to cases where the act wasn't witnessed at all. A man jumping out a window or two people sleeping is static. I am talking about the psychological continuity of witnessing the betrayal actively unfolding.
Go on.
Let's look at People versus Gabriel. The definition of surprise there means to come upon suddenly and unexpectedly. In Gabriel, the accused peeped through a hole in the kitchen door for a while.
The Peeping Tom case.
Yes. He watched everything from the preparatory acts all the way to the actual commencement of sexual intercourse. The court ruled this was still by surprise. He didn't burst in at the first kiss. He watched the dam break.
So you're saying the rage builds over time?
Exactly. The law recognized that the rage builds and culminates. The focus of the court was on the continuity of the psychological devastation, not demanding a snapshot photograph of the exact moment of discovery.
That's an interesting point, though I would frame it differently. In Gabriel, the accused still ultimately witnessed the actual commencement of sexual intercourse.
True.
He met the objective standard, even if he watched the prelude first. But your argument about psychological continuity, this idea of the dam breaking, opens up a very dangerous question. How far are you willing to stretch this psychological continuity?
I don't think it's about stretching it endlessly.
Well, the law explicitly says the killing must happen in the act or immediately thereafter. U.S. versus Vargas lays down the rule beautifully. The discovery, the escape, the pursuit, and the killing must all form part of one continuous act.
Right.
If a husband finds his wife in the act, the lover jumps out the window, and the husband chases him down the street and kills him in one unbroken sequence. That is covered. But if there is a break in that continuity, if the flash flood recedes, it becomes calculated murder.
But the break in continuity is measured by the duration of the passion, not by a ticking clock. Let's bring in People versus Abarca to solidify how the courts actually respect this psychological reality.
Okay, let's talk about Abarca.
In Abarca, the victim was killed about an hour after the discovery of the sexual intercourse, a full hour. Under a strict literal timeline, you would say the immediately thereafter window had slammed shut.
Many would, yes.
But the Supreme Court deemed the shooting and continuation of the pursuit. The standard they established is whether the killing is the proximate result of outrage overwhelming the accused. As long as the accused is motivated by the same blind impulse triggered by the infidelity, Article 247 applies.
I'm not convinced by that line of reasoning because it threatens to turn a momentary absolutory cause into a lingering license to kill.
It's not a license to kill. The law fundamentally punishes criminal intent. Here, the court recognizes that the normal, rational intent is entirely hijacked by the trauma of discovery. That blind impulse doesn't neatly resolve itself in 5 minutes.
I acknowledge the Arbica ruling, but we have to look at how the court draws a hard line against extending that blind impulse indefinitely. Let me tell you the story of People versus Rabendabown.
Oh, the bolo knife case?
Yes, this is the perfect counterweight to your flood metaphor. A husband walks into his bedroom and finds his wife in bed with another man. But he didn't act immediately on that blind impulse. He didn't snap.
He just yelled at her, right?
Exactly. He merely upbraided her, yelled at her, and told her to leave the house. It was hours later, after an argument, that his wife called him names, attacked him with a bolo, and wounded him twice in the abdomen.
Ouch.
He wrested the bolo from her and ended up killing her.
Which is a completely different dynamic.
Exactly. And the court did not apply Article 247. The killing was not on account of finding her in bed. It was on account of the subsequent fight and the bolo attack.
Yes, but that actually proves my point.
How does that prove your point?
The rage that leads to the killing must be directly tied to the act of infidelity itself, not external factors, not a rekindled anger an hour later if the initial impulse had subsided.
Rabendabown actually proves my exact point about the mechanism of the law. The court didn't apply Article 247 there because the husband's reaction wasn't the blind impulse of betrayal. We know this because his immediate reaction was literally just to scold her.
Okay, I see what you're saying.
His violent reaction was the result of being stabbed with a machete later on. That's self-defense, or a completely different physical confrontation. It is not the psychological overwhelming of the senses that the law contemplates for Article 247.
But that's exactly why we need objective boundaries.
The distinction the court makes in all these cases, Gonzalez, Gabriel, Abarca, is about identifying the true genesis of the violence. If the genesis is the sudden, catastrophic realization of betrayal, the law recognizes that a human being in that exact moment is temporarily bereft of reason.
I hear you, but the proof is the issue.
Whether he watches the preparatory acts escalate through a door or chases the man for an hour while blinded by rage, the psychological mechanism is the same. To demand that he only gets the benefit of the legal erasure if he interrupts the exact moment of physical penetration is to demand that a person losing their mind act with the precision of a legal scholar.
It is not about demanding precision from the accused. It is about demanding precision from the courts before they downgrade parricide to banishment. The burden of proof must remain staggeringly high.
Staggeringly high, sure, but not impossible.
If a spouse is killed, the baseline assumption of the legal system must be parricide. To earn the exception, the defense must invoke and objectively establish the requisites. We see this in cases where the court refuses conditional pleas of guilty.
Oh, right. You can't just plead guilty to distiro.
Exactly. An accused cannot simply say, "I caught her, give me distiro," and walk out the door. The court must receive rigorous evidence on the surrounding circumstances. And what is the strongest, most undeniable evidence? Literal, physical coercion.
I disagree.
It removes the ambiguity, it removes the he said, she said of whether a touch was merely inappropriate or whether an embrace was actually the prelude to intercourse.
But that evidentiary strictness results in gross injustice when applied blindly to human trauma. Look again at the dissenting opinions in Gonzalez. To deny the application of Article 247 to a man who catches a lover buttoning his pants entirely because of a technicality of timing is to ignore the spirit of the law entirely.
It is a harsh line, I agree.
The law wasn't written to reward perfect timing. It was written to acknowledge the limits of human endurance when faced with the ultimate marital betrayal.
And I would argue the spirit of the law must always be balanced against the sanctity of human life. Human passion is messy, chaotic, and entirely subjective. The law cannot afford to be.
Even when the law is dealing with passion?
Especially then. By strictly interpreting Article 247, by requiring literal carnal acts, or at the very least immediate unbroken continuity from a clearly established carnal act, the legal system prevents the Desierro exception from swallowing the rule against parricide.
I see.
Objective standards, as rigid and clinical as they may seem, are the only mechanism the state has to protect human life. They ensure that murder is not easily excused by claims of heartbreak.
That's a compelling argument. But have you considered that a legal framework that expects a betrayed spouse to act with clinical detachment during a moment of profound psychological trauma is fundamentally flawed?
I wouldn't call it clinical detachment.
We cannot regulate human beings as if they are machines. If the law accepts that the discovery of sexual betrayal creates a justified burst of passion so overwhelming that taking a life is met only with banishment, then the law must accept how that passion actually manifests in the real world.
Which is messy.
Very messy. It does not wait for clinical proof of penetration. It explodes the moment the betrayal is undeniable to the senses. If the law ignores that reality, it fails the very people it was designed to understand.
It forces us to continually ask what exactly the law is punishing, the physical outcome or the state of mind that produced it. This tension between objective standards and subjective realities is a theme we see throughout this syllabus.
Oh, absolutely. Like with tumultuous affray.
Yes, where multiple people are in a chaotic brawl and someone dies, but you cannot trace who struck the fatal blow. The law is forced to objectively assign liability based on participation rather than subjective intent.
Or intentional mutilation.
Exactly. Where the law must determine if the crime was just physical injury or if there was a specific subjective intent to deprive someone of a body part. The law must always anchor subjective intent to objective facts. The law tries to measure the exact moment a mind snaps, but human passion will always test the limits of our legal scales.
It certainly will. There is definitely a lot more to explore in this material for anyone interested in the intersection of psychology and the penal code.
Very true. Thank you for joining us.